May I please, your lordship?
Yes.
Lordship, I beg to mention item number 12, my lord. My lord, in this case, Angus Council is out of station, my lord, due to medical emergency, my lord.
Mr. Rafiq,
M.H. Chaudhary.
MH.
I'm making on behalf of M.H. Chaudhary.
When is he coming back?
He has given leave note to up to 7/5.
List this on the prayer made on behalf of Mr. M.A. Chaudhary, who is stated to be under medical attention. List this matter again on 9/5/2020.
Obvious.
Yes, Mr.
Item 24.
No, item number 12.
May I please, your lordship? I beg to mention item 4 and 11 of. I beg to mention item 4 and 11, lordship. Lordship may fix this.
I may not by me.
Uh,
4 I'll not take up because I know the man. Ref employer, I know him. I'll not
lordship,
take
11 then is on second half.
item number 4. List this
Then
matter
lordship,
before any other bench without me.
Item number 4, I'm appearing, your lordship.
4.
11 on second half.
Mr. Bora, I know that man.
Yes.
I think he's retired by now. Or he's still
Not
in
that
service.
1 year, I think.
So I think I'll not take up. And next item.
11, lordship, on second half. Second half. We fixed on second half.
Okay, when it is called, you make a mention.
Item
yes.
number 4.
4 I have not taken.
Hello, I beg to mention for listing of the pending matter.
May I please, your lordship? I beg to mention item number 24.
Item number?
24. With the consent of other party. This
Why is this not being done? This matter is not being done. Any problem before this court?
No.
Then it's always being adjourned.
See with the marriage
After
party.
lordship raised the question of maintainability of the
That is the issue. We come prepared daily, and unfortunately, this court has to read daily. That's a manufacturing defect. Can't help it.
Next
But
week we'll do
Huh?
next step,
when do you want it?
like next week.
Friday, my lord.
On the
No,
prayer
no,
of
this-
Mr.
Next week.
8, on behalf of Mr. 8 Todi. When, Mr. Majumdar?
My lord, Friday.
This Friday.
No, lordship, this week
Okay.
is busy.
List this matter again on 29/4/2024. No further adjournment would be made in the matter. Okay?
May I please, your lordship? I beg to mention for listing.
Listing all you give it here. Second and DD Bob. Yes,
With the
Mr.
consent of the other side, lordship. Item number 2. It is almost concluded from the other side. I have to address, there's a request from the government that I have to appear.
Fine,
It
no
will be
problem.
taken
When
up
do
day
you want
after
it?
tomorrow.
Huh?
Day after tomorrow, Thursday.
Thursday. Done.
Deeply obliged.
Item number 2. It by slip mutate thegi. On the prayer made by Mr. D. Soikia, who has now entered appearance in the matter. D. Soikia, Advocate General Assembly, list this matter again on 25/4/2020.
Highly obliged.
Please, Lordship. Lordship, I beg to mention item number 21 of today's daily list, Lordship. Lordship, in this matter, we were supposed to file our affidavit by today, Lordship. I need, my lord, some developments that took place, so we have to add some more points, Lordship, some more facts. My lord, will kindly take it up in the coming, my lord, maybe Friday, my lord. Friday. I've taken the consent, my lord. Okay.
Give me some other reason. This is not convincing. Give me some other reason.
We'll be filing it, Lord.
You give me some other reason. This reason is not convincing.
My lord,
Have you informed Mr. Purkhaisto?
I have informed, my lord. I have already informed him.
On the prayer of Mr. A. Fukan, Planet Standing Council, Elementary Education Department, who submits that the affidavit in the matter would be filed was by Friday.
By Friday, man.
By Friday. Friday ka date de dena. Accordingly, list this matter again on 1/5/2020.
Deeply obliged.
But this is not for delivery of what I think I had kept for
Yes, my
further
lord.
hearing.
My lord has kept it for hearing and have mentioned on the last occasion that I'll pass the order.
But they were supposed to address me further in the matter.
My lord,
But unfortunately, on that day, 7/3, I was not here.
yes, my lord.
So when do you want it?
My lord, my friend, he was here for some time, but he had to attend some court matter, he told me. So
When? Give me a
any
convenient
day
date.
convenient to my lords,
No, I'm here. You give me a date.
would it be possible today or any other date, my lord?
First week of May
First week,
or last 30th.
Yes, my 30th.
30th is too much. Let it be on first.
For my lord, any date.
First,
On any date.
second May.
Second, my lord.
Although the matter was listed for delivery of orders, however, the parties have made have submitted that further submissions is to be made by them in the matter. Accordingly, list this matter again on 2/5/2024 as a top of the list matter.
My lord.
Top of the list.
I'm
By
obliged.
slip, PD.
I'm highly obliged, my lord.
Yes. You can give me that book if you want, then that will solve the problem.
Pardon, my lord.
You can give me that book.
This,
No, the other one.
this one. There's nothing. Just for my guidance.
Yes,
My lord, if lordship takes it up for final disposal, my lord, we can.
naturally.
Yes.
Yes, Mr. Nath, what do you have to say more?
Yes, if final disposal will not go to the matter.
Huh?
You will not much time because we have already argued. We have to just make my submissions like what my learned friends did just now. Shall I make my submission or he will make the submission?
I think, I think, Mr. Nath, we have just lost a bit here. Let's, Mr. Nath, just
Yes, yes.
recapitulate.
I am also ready if my senior counsel is also starts.
He is ready. He is always ready.
Is ever ready.
Yes,
Bec-
sir.
Because there's only one case.
Mr. Nath,
My lord.
the last occasion, there was a submission made that this award having been approved on 18/12,
1812.
right? So in terms of that, it had attained its finality. And it, any
That
challenge
was-
to
that
be
was-
made is to be made within
30 days.
30 days,
17 years.
17/1.
17-2.
So that is the issue we will have to first thrash out.
Yes, yes.
First starts out that
Yes.
issue. If that overcomes,
Then
then the merit.
I'll make my submission of that, my lord.
that you may.
My lord, there are two parts.
Hmm.
Now, my learned friend has referred the other day the judgment of the Jammu Kashmir High Court, my lord. Why is it two parts? One is, if your lordships held that, section 17(2), if it's a mandatory,
ID Act to be Industrial
ID Act.
Disputes Act. Who is it? No, what is it?
Lordship wants this, I have. That flag.
Asani. Enough. 17.
17-2.
Huh.
Let us read from the 17(1).
Hmm.
Every report of a board or court together with
Hmm.
any minutes of dissent recorded therewith,
Hmm.
every arbitration award and every award of the labor court, tribunal or national tribunal shall, within a period of 30 days from the date of it receipt by the appropriate government, be published in such manner as may be appropriate government may think fit. 2. Subject to the provision of section 17A, a word published under subsection 1 shall be final and shall not be called in question in any court of law. That was his submission, my lord. Now, I'll make my submission on this, my lord. So for this section 17, see, section 17(2), it's basically, my lord, it's keeping his shoulder on section 17(1), right? Now, 17(1) is a directory.
Hmm.
If it's a directory, my lord, then, my lord, that provision automatically, my lord,
Whole provision will become direct.
not bad, I don't say bad. Like the period of 30 days, I think will not have much meaning, I will say that.
No, it'll the 17
Yeah,
whole,
now, in
17
this
1 and
regard-
2 would be directory.
Directory. I've got this judgment on this, my lord.
Hmm.
I'll just give to your lordship, my lord. A 1968, 5. Five. My lordship may kindly take this copy. Yes.
This is continuing legal education for me.
My lord,
Continuing legal education for me.
yeah, for everybody.
Yes.
Paragraph citation is 2013-10 SCC 185. Paragraph 5, my lord. Paragraph 8. My lord, 1 minute, my lord, 1 minute, my lord. That is not the one, my lord. Sorry, 6, my lord. 1 minute.
This
This
is
one, my lord.
11A.
My lord, this one. Sure, sir, yes. Yes, we can agree. Yeah, 1960, yeah, 1960. Para 6, my lord. Para 3. 1968, 2 to 4.
1968, 2 to 4.
My lord, para 6. Para 3, second page number 3, my lord.
Hmm.
Keeping the above principle, we cannot but hold that provision as to time in section 17(1) is mere directory and not mandatory. Section 17(1) makes it obligatory on the government to publish the award, my lord. That's what I want to say, my lord. Now, the time limit of time has been fixed as showing in the calculations such and such. See the last 3 lines.
17(1). Okay. To that
17(1).
extent,
See the last line of this para, which your lordship has read. See the last 3 lines. What was said in the earlier passage from the judgment in Supra merely shows that it was not open to government to withhold publication, but this court never meant to lay down that period of time fixed publication was mandatory. So, my lord, relying on this judgment, my lord, and also my lord, other day I have given the judgments. I think it's in the lordship's file.
yes, it's with me.
Take the judgment, my lord, this honorable court, WPC number 2057, my lord. And details have been discussed.
Our High Court judgment.
Yes, recent judgment. 26/5/22. Let us read this one, my lord. It is not. Para 8, my lord, maintainability.
Hmm.
Para 8.
Hmm.
Before considering the submissions made by the learned counsel, let us first deal with the preliminary objection raised by Mr. Shahu, learned counsel for that such. By relying upon a judgment of the Honorable Supreme Court in the case of Radhesham versus such and such, the learned counsel submits that Honorable Supreme Court in the said decision has laid down that judicial orders of civil court are not amenable to jurisdiction under Article 226 of the Constitution. And such challenge can only be made by making a recourse to Article 227, not by 226. Next, on the other hand, the learned counsel for the petitioner submits that aforesaid preliminary objection is a misconceived one, inasmuch as judicial review is a basic structure of the Constitution of India, which cannot be taken away. He further submits that there is a difference between court and the tribunal, and therefore, decision of the Supreme Court in the case of Radhesham is not applicable. Before going into, shall I read, my lord?
Yeah.
Before going into interest merit, let us first deal with the preliminary objection raised. The objection regarding maintainability appears to be structured on the case of Radhesham. However, a bare reading of the said case will reveal that restrictions were imposed upon in challenging judicial order of a civil court. Honorable Supreme Court has also laid down that such restriction necessary in view of remedies prescribed under CPC, my lord itself. Next, This court is unable to accept the submissions made on behalf of the management that court per se means a tribunal. While a court is strictly guided by the CPC, there is no such application in a tribunal which has its own rules. This court is also of the opinion that since certain powers of the civil court have been vested upon a tribunal by section 1111(3) of the Act, tribunal can be assumed to be a civil court. Further, the Industrial Dispute Act, the definition of court is given in section 2F, which reads as follows. That is there, my lord. Court definition in this case, unless such and such F2F, my lord. Court means a court of inquiry constituted under this act. Therefore, it becomes apparent that the expression court used in the Industrial Dispute Act cannot be said to be means a civil court. Raising another preliminary issue, the learned counsel further submits that under section 17(2) of the act, my learned friend's point, all awards are final and therefore the same cannot be put to challenge by way of writ petition. As regards submission made on behalf of the management that use of the expression final in section 17(2) of the act would indicate that no challenge by way of judicial review would be maintainable. The Honorable Supreme Court in a number of judgments has laid down that judicial review is a basic structure of the Constitution of India and same cannot be tinkered by the Legislative Act. And this court has referred the L. Chandra Kumar case, my lord.
And final conclusion is that the judicial
Paragraph
review
18.
cannot be para 18.
Yes. Paragraph 18, my lord. This court has no hesitation to reject the preliminary objections regarding the mental of the writ petition. It is settled position of law that doctrine of judicial review is an essential part and basic forms the basic structure of the Constitution of India, which cannot be amended by legislative restriction. The next 1-2 lines only. Paragraph 19. In view of the fact that writ petition has been held to be maintainable, this court would now be required to answer the issue. That's a different issue, my lord. So, my lord, one judgment of this honorable court is there, my lord.
This court said no restriction can be placed on the power
My
of
lord, my lord.
judicial.
No, my lord, there is, I want to just place another judgment. My lord. Yeah. Lordship may kindly see there's a flag mark 3A. I have given the other day.
It's there.
Just let us go through this one, my lord. It's a paragraph 5. First, paragraph. My lord, where is paragraph 1 in this one? There is no paragraph 1 in this. Start from paragraph 2. Law finder. This is an appeal preferred by the management against the judgment of the division bench of the High Court of Karnataka in writ appeal number such and such, confirming the judgment of the Rani single judge in writ petition. That means what? See, my lord, against the award, writ petition 226 was filed. Against the writ appeal was filed. Against that matter went to the apex court, my lord. Paragraph 2. Now, if you lordship come to paragraph 5. Now, counsel appearing for the workman contended that there is no finding record labor court that workman was the probationer. Labor court by virtue of powers conferred under.
This is basically on merits.
I got it.
Basically on merits. Not with regard to that preliminary point. It will be on merits.
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 Merits. Yes, my lord. 9. Can we see the 9?
9.
Yes. It is well settled that the power of the labor court under section 11A are wide and that it would be open to the High Court in justifiable cases to modify the order of the labor court. Because why it was said? Because this present case came after writ petition, then writ appeal, then the Supreme Court, my lord. And next line, it is also permissible for this court under Article 3 Constitution of India in approved cases. So that means what, my lord? Harmonious conjoint reading, my lord. What it says, my lord? Award, writ petition, writ appeal, 226, 136. My lord, I just want to another one. Janata Bazaar. 4. Lordship may kindly take this serial number 4 I have given, I think, my lord, this one.
4 you have not given.
Then I'm giving. I marked the 1, 2, 3, 4 become easier, no, my lord. Eye catching. Hey. My lord,
One request, Lord. kindly order the registry to disenclose this. Can't hear.
That has
anything.
been already done, but unfortunately because of Bihu and
Can't
elections,
hear the other
people,
side.
people are not. For that, you will have to take an appointment somewhere else.
My lord, this is also about. No, I heard it. It is appointment.
Appointment somewhere else.
Yes, yes.
Yes, Mr. Nath.
My lord, paragraph 5, my lord.
Hmm.
Paragraph 5, page 2. This is also against the award. Being agreed by the common order passed by the landed single judge, both the parties filed writ appeals number such and such before the division bench. The division bench found that the labor court had arrived certain things, my lord. I want to show, my lord, the writ
I got,
petition labor
you
court.
want to
that's
show me that after the decisions of the, it's not that the decisions of the labor court are not being challenged. It has even gone up to the Supreme
all.
Court.
Yes, and my
So
lord,
that bar is not there.
I want to say, my lord, there are a number of cases I found. Where I found from the award, it came to writ petition 226, then writ appeal, my lord. So,
I think you should refer to your three.
Three.
Case number 3,
yes, case number 3.
State of Haryana versus Haryana Cooperative Transport,
Yes.
paragraph 14.
Paragraph 14, yes. Yes, that's on section 9. Section 9(1) of the act says, constitution of the chairman of the board, my lord, which cannot be challenged in the court of law in any manner whatsoever the wordings are there. On that is under Industrial Dispute Act. In respect of that, the Honorable Apex Court said no, it's permissible, my lord, Article 100-226. Last paragraph, my lord, the name of our High Court is also there.
Hmm.
Last paragraph. It is true that section 9(1) is worded so widely and generally that it could cover any and every challenge to the appointments to the particular post therein mentioned. But it is impossible to construe the provisions as in derogation of the remedies provided by Article 226 and 227 of the Constitution. The rights conferred by those articles cannot be permitted to be taken away by a board, and general provisions in the nature of section 9(1) of the Act. The words in any manner which occurs in section 9(1) must therefore be given a limited meaning so as to bar the jurisdiction of the civil code as in the ordinary exercise of their powers to entertain a challenge to appointments mentioned in the subsection. The High Court of Assam, Bombay, Rajasthan have taken, like the High Court of Punjab, Haryana in the instant case, a correct view of the scope meaning of section 9(1) of the Act by limiting its operation to ordinary powers civil code. The rights conferred by Article 226-27 can only be abridged or taken away only by appropriate amendments of the Constitution, and their operation cannot be whittled down by a provisions like the one contained in the section 9(1) Act. It's, my lord, you need the amendment of the Constitution, Article 368, my lord. Only
And
that
your case number 2,
Case number 2, yes.
that is, I think, touching on the topic.
NTPC, Calcutta. Calcutta, my lord, division bench.
Calcutta division.
Yes,
You can come to page 5,
page 5.
top portion.
Yes. The answer will be the, yes. There are 9(1), my lord.
9(1),
See,
the
there are
issues are in
paragraph 8, see the Roman 3.
Roman 3 is the issue.
Roman is the issue. It
Then
is,
you come to
yes,
the
it is in
Roman
the
3
paragraph
is
10(1).
being considered
Paragraph 10, my
in-
lord.
paragraph 10.
Yes. So let me read from here, my
Ah.
lord. This is important because other the lordship is said at the bottom of the paragraph, something is there, but I have gone through it, my lord. Yes. Now, with regard to the last issue as to whether a word passed by the Landed Industry Tribunal has reached finality, Mr. Bhattacharya, Landed Council appearing, my lord, his lordship knows, my lord, Mr. Vikas Bhattacharya. Everybody calls him Vikas, the lordship knows, my lord, he comes here. Section 17A and section 17A of the Act fervently argued there. A word passed by the Industry Tribunal has attained finality in terms of the aforesaid provisions of law and is immune to challenge, and accordingly writ petition challenging such award is not at all maintainable. In order to find an answer to the ground of maintainability of the writ petition on award reaching finality, we may profitably refer to few decisions of the Honorable Supreme Court. Paragraph 10(1), my lord. Let us go to paragraph 10(2). Further, in the decision of the state of Haryana, the Honorable Supreme Court, while dealing with the provision of section 9(1) of the Internal Dispute Act, which provides that no order of appropriate government or central government appointing any person as the chairman or any other member of a board or court or as the presiding officer of a labor court, tribunal or national tribunal shall be called in question in any manner, observe that right conferred by Article 226 and 227 of the Constitution can be abridged only by an appropriate government amendment of the Constitution. Their operation cannot be whittled down by provisions. My lord, the one I read just now, my lord. 3. Held that High Court in excess of the jurisdiction can consider the validity of the appointment under such. Next, there are 10.3. For the Honorable Supreme Court, in the case of Perry and Company, while dealing with the Section 50 of the Madras Shop and Establishment Act, lays down that the decision of the Labour Commissioner will be final and incapable of being challenged in any court of law. Observe that, in spite of such statutory provisions, the Superior Court is not absolutely deprived of the power to issue writ, although it can do so only on the ground of either a manifest defect of jurisdiction in the tribunal that made the order or a manifest fraud in the party procuring it. Thus, from the efforts decisions of the Honorable Court, it is clear that an award under the Act cannot said to be immune to challenge and no writ petition is maintainable. Rather, it goes without saying that High Court in exercise of its jurisdiction can intervene where there is an irregularity in the procedure or where there is an error apparent or contrary to principle of natural justice. Accordingly, argument advanced on behalf of the respondent in this regard falls short of merit, my lord.
So while saying that it's not immune to challenge, it has constrained, it has reduced the scope,
Yes, yes, it is always there. If irregularity,
irregularity,
perversity, or maybe something few things,
perversity,
that I'll show.
procedural.
That I'll show, my lord, is there. That I'll show, my lord. Now, my lord. I will get you. So, my lord, so far this 17.1, 17.2, and my lord, jurisdiction of the court is concerned, my lord. I think from this judgments, it is clear, my lord. And although there is judgment of this honorable court also, my lord.
This judgment of
Lordship,
the Honorable
one-
Court, coordinate bench is binding upon.
Yes, my lord, one thing I have noticed, my lord. Even if your lordships take the case of the Jammu Kashmir High Court, my lord, just let us take it. Let us see, my lord. Yes. This says, para 10.
You have a copy?
Yes, yeah.
No. Can you give me a copy? Jammu Kashmir is not.
Fine.
Just a moment, maybe. No.
Lordship, I come to page 37 of the preparation. Actually, the relevant paragraph is 7, then
Hmm.
10.
Yes.
37
Page 30.
in the High Court of Jammu Kashmir.
Yes, yes.
Monomohit Industries.
Yes, Monomoy.
Paragraph, Mr.
7 and
Not-
10.
10, lordship will come to paragraph 10. Because it traveled to High Court, that's why. Award was. Law is settled at not that by challenging an award under Act of 47, Labor Court exercises the power jurisdiction of the Civil Court. My lord, there is no dispute one thing. Labor Court is the lordship has seen the definition, so 2F. 2F, just one second, just a second. 2F. 2F says, court means a court of inquiry constituted under the Act. Lordship will find it, section 11, your lordship will find the procedure, what procedure they follow?
Hmm.
CPC.
CPC.
That's what.
Because CPC has been conferred, it has been inbuilt,
Exactly. It doesn't mean
that it's a civil court.
a civil court because right from the day one, last all these days, I tried to find out one case where the apex court says industrial tribunal
It's
is
not a civil court. It's not a.
My lord, I have failed, my lord. Maybe there are, but I
It has the trappings of a civil court to the extent the power is conferred. to it.
exactly,
That's all.
That's what, my lord. So this
No
judgment, my lord,
tribunal can be said to be a civil court in that connection.
Yes.
It's only to the extent of calling of witnesses,
That's what, call witnesses.
affidavits, and
Exactly,
all
exactly.
those,
Otherwise, how they will come to a
they'll
conclusion?
not be.
Yes.
Okay,
If had it been a civil code in the act, that could have written, my lord. Court means it's a civil code.
civil code. It's
Exactly,
not a
my
civil code.
That's why I find the judgment passed by the Honorable Jammu Kashmir High Court, my lord, the decisions which I have revered, my lord,
They're not
number of
considered.
judgments, my lord. Operative part will be paragraph 16, I think. 15 also. 15, 16. Looks like it. जरा एक बार कर- क्या करोगे? हाँ, ये- I don't know. My lord. So, my lord, so since there is a judgment of our High Court here, in the Jammu Kashmir High Court, it says it's a civil code. But civil code, it is, I think, incorporated the terms, my lord, misconceived terms, I'll say. So far this judgment is concerned, my lord. So lordship may not rely on this, my lord. And my lord, one thing, my lord, whatever I am submitting now, my lord, in a short note I have made so
No,
that
nothing
it
like-
become easier for. Whatever submissions I made, my lord, I made in this notes, my lord, so that.
Yes, Mr. Anything more on the
No,
point
no,
of
my lord, these are things, my lord.
maintainability?
Now
Let's
I
first-
think, yes, yes. Now if your lordships held that it is maintainable, then the next question comes.
Next question has to have the merits.
Yes, on merits, my lord.
We'll go to that.
Yes,
Let
that's
me
the
hear it.
second part,
Let me hear it.
my
first.
lord.
But I also prepared a very small note for your lordship's convenience.
Satisfy me on 17.
Yes, yes. I'm coming on that.
Yeah, perhaps. Let's see.
My lord will come, this maintainability issue. That I have annexed one judgment. Even this, can I go? Kindly come to my lord is 8.
Hmm.
That is the,
Glaxo.
yes, Glasgow.
Hmm.
GlaxoSmithKline. GlaxoSmithKline in paragraph, my lord. The whole thing starts here from. Start from paragraph 16 onwards.
Paragraph 14.
16, my lord. 1/6. Sorry, from 13 onwards. Sorry. The High Court finally allowed the petition. I said, paragraph 13. The High Court finally allowed the writ petition by the impugned judgment and order on the ground that the statutory remedy had become ineffective for the respondent due to the expiry of 60 days from the date of service of the assessment order. Inasmuch as the appellate authority had no jurisdiction to condone the delay after expiry of 60 days, despite the reason mentioned by the respondent of an extraordinary situation due to the act of commission and omission of its employee who was in charge of the tax matters, forcing the management to suspend him and initiate disciplinary proceeding against him. Soon after becoming aware about the assessment order, the respondent had filed the appeal, but that was after expiry of 60 days period. The High Court was also impressed by the contention pressed into service by the respondent that it ought to be given the opportunity to explain to the authority about the discrepancies between the value reported in the CST returns and the amount.
This will not help you.
This will help.
Underlying factor here is,
Well, I'm coming to the, there are more below.
no. The underlying factor in Glaxo is that if there is a procedure prescribed under the statute, then in spite of the power of the court to exercise its power of judicial review, it has to give some meaning to that provision. That is not the case here.
I'm coming. There are some more paragraphs, my lord. In next page, my lord, in page number 6. 698,
number?
Lordship will see at page.
Paragraph.
Yes, I'm talking the paragraph 15, my lord.
Hmm.
We may usefully refer to the exposition of this code
Hmm.
in Titaghor Paper Mills Company Limited versus State of
Hmm.
Orissa, wherein it is observed that where a right or a liability is created by a statute which gives a special remedy for enforcing it, the remedy provided by that statute must only avail of.
No dispute on that.
What I'm trying to do. I'm not concluding my arguments on this point. Now, my lord, if lordship looks into it, this whole paragraph, if I can, may be allowed to read. What the underlying, the ratio laid down by this particular judgment is, my lord, in my humble understanding, that when there is a provision given in the statute that cannot be disrespected by a court of under Article 220.
You come to that italics portion of
Yes,
para 15.
yes,
The act
yes. Under the
provides,
scheme of the act.
the act provides for a complete
The act
machinery.
provides for a complete machinery to challenge an order of assessment.
Ah.
And the impugned order of assessment can only be challenged by the mode prescribed by the act and not by a petition under Article
So
226.
that is the distinguishing factor
Yes.
there and here.
I can understand why I am reading this, my lord, to give lordship a background, the views of the whole case of this particular case. Now, what is the finding of the honorable court?
Hmm.
There are three classes of cases in which a liability may be
Paragraph?
established. I'm reading from. that
There
only.
are three classes, huh?
Yeah. In which a liability may be established founded upon statute, but there is a third class, vice, where a liability not existing at common law is created by a statute, which at the same time gives a special and particular remedy for enforcing it. The remedy provided by the statute must be followed, and it is not competent to the party to pursue the course applicable to cases of the second class. The form given by the statute must be adopted and adhered to.
Fine.
The rule laid down in the passage was approved by the House of Lords in Neville versus London Express Newspaper Limited and has been reaffirmed by the Privy Council in Attorney General versus Gordon Grant Company Limited and so and so. It has also been held to be equally applicable to enforcement of rights and has been followed by this court throughout. The High Court was therefore justified in dismissing the writ petition in limine. Next,
Mr. Chamua,
my lord, I'm
just for my understanding,
my lord, just this.
my understanding, a provision under the Public Premises Eviction Act.
My lord.
You go, an order is passed by the estate officer, and the act provides for the remedy there. That is an appeal before the district judge.
My lord.
Now, there are a line of judgments similar to Glaxo, wherein a writ is held to be not maintainable. It is in that context, this thing is said that if there is a remedy prescribed, then you will have to follow that remedy. And this court will have to give it a precedence.
I'm not saying, and this is not even my arguments,
Hmm.
that there is, the writ petition is not maintainable under Article 227. My respectful submission is, my lord, that writ petition ought to have been filed within a period of limitation of 30 days. This is my argument. And
This judgment will not further that. Give me a judgment furthering that
Yes.
concept.
No. What I'm trying to show your lordship is this. If lordship enhances the scope of subsection 2 of 17, that you can file at any stretch of time without expelling the delay, then, my lord, the purpose of the whole act will go. Writ petition, my lord, I understand there is no limitation. We can
But-
come at,
Latches
yes,
would come in.
here is not even a single sentence in the entire writ petition that why they have filed it after 30 days. Moreover, my lord will appreciate two things more. I'm coming on to this. Jute mill, this Naga jute mill is a state within the meaning of Article 12. It is a state enterprise. I'll show from the documents.
No,
I'm
you
next.
stick to first 17.1. 17.1
I'm
and
coming,
2 you
I'm
clear.
coming. Since government has accepted the award and published under the 17.1, then my lord, the scope of challenging by the same state government's instrumentality before a writ court,
Show me that provision that it cannot.
my lord, it cannot, there cannot, a negative hyphen approve.
I'm not on that. They are a independent
they are a-
autonomous body. They are an autonomous body.
And I'll show the deep and pervasive control of the government. I have annexed the documents.
Fine, no issue. No issue. But under the Act, Industrial Dispute Act, irrespective of whether it's a government company or a
Lordship,
private company,
Lordship, just allow me to go in my flow, my lord. I will come one after another and Lordship will got all the answers, my lord. I respectfully submit, my lord.
Hmm.
This paragraph, last part of the paragraph 15 of this judgment.
Hmm.
And let's see. From paragraph 15 of the last part, in the subsequent decision of Mahputlal Industries Limited, this court went on to observe that an act cannot bar and cartel remedy under Article 226 or 32 of the Constitution. Right, man. The court, however, added a word of caution and expounded that the Constitutional Court would certainly take note of the legislative intent manifested in the provisions of the Act and would exercise its jurisdiction consistent with the provisions of that enactment. To put in differently, the fact that the High Court has wide jurisdiction under Article 226 of the Constitution does not mean that it can disregard the substantive provisions of a statute and pass orders which can be settled only through a mechanism prescribed by the statute.
that
That last
few
sentence.
words
And I understand.
clicks
Now-
the issue.
Next, Milord. Now they have to clarify before your lordship whether
And
they are
on
under.
merits, we will go.
No. Whether
Your
they are,
argument is 17.1 and 17.2 read together. After 30 days,
that is,
total
I'm
bar.
sorry, the below, after that, I have added now from my side.
No, that will come when we consider the
And I
merits.
appreciate, Milord. Whether they have to clarify before this honorable court, whether they have come under 226 or 227. If it is a 226, they have come under 226. If it is a 226, then lordship will look into the decision-making process, not under decision. Lordship will look into the decision-making process only and not on the decision. Merit of the decision, your lordship, they cannot question under 226. Now, if lordship for the purpose of do the complete justice, converts this petition to a 227, then what can your lordship do? What is the periphery under 227? That will come to later on while I'm arguing on the merit. Now the question is, they do not know whether they are under 226 or 227.
are not
Their
on
petition
that.
is under
You
226,
just sat-
arguing on 227
you
cannot
just
be accepted.
satisfy me that I will,
No, my lord, their
take care.
petition is under 226, but they are arguing on 227.
you first satisfy that 226, 227 apart. This petition in any form is not maintainable. That was your argument.
Earlier, I was of the view that this petition is not at all maintainable. Now, after refining the judgments of the Honorable Supreme Court and the High Court, my respectful submission is, my lord, lordship can definitely entertain a writ petition, but within that 30 days periphery. If they have not come within the 30 days, they must give an explanation why they are not approaching this court within 30 days. Otherwise, this judgment will hit.
If there is an explanation, then 30 days
Then-
beyond also I can.
Then your lordship is to accept that explanation.
So 17.2 is not a bar. Your argument on the last occasion, if you want, I can rewind it.
Yes.
Your argument was that this writ petition in any form after 30 days is not maintained,
Yes, my lord.
right?
Yes.
So now you are giving up that argument. You have
Now,
added
again,
certain
this
other
lordship
layers
is-
to that.
Again, it's a constitutional court, my lord. 226, how can I respect
Otherwise,
your
then why should I
lordship?
have wasted my around half an hour
No.
only on
What-
that point? Yes,
Fine,
Mr.
my
Nath,
lord will appreciate.
argue on merits.
No, my lord will appreciate, my lord. This is a duty being an officer of the court, my lord. That to show to your lordship, the
fine.
judgments of the Honorable Supreme
lord.
Court,
Let us
being-
go on merits.
giving abundant caution to the constitutional court.
Your this points, we will take it up on merits. This point that you have raised now
Yes,
is a point which will be considered on merits.
yes, they have to.
So
clarify
17
whether
we
they
are
arguing
giving up.
This case in 226 or 227.
That Mr. Nath will argue.
Yes,
Yes.
I'll respond.
So
There's the reason.
17.1 gone.
There's the reason. Lordship might sort that reason argument in my written argument, Lordship will find, my lord. In between first, there's a star, no? Eh? That's the reason I made it two parts, my lord. 226 stop.
No, I was under the impression that he was arguing on the other day that there are decisions of
yes.
the Supreme Court which says
Yes.
that you cannot proceed.
No, it's a directory.
I did not find any decision.
Even then, my lord, Supreme Court says that the constitutional court cannot disregard the statutory provision.
We are not disregarding. Provided there is a method of redressal prescribed therein.
And it's directory,
Yes, merits.
my lord.
In your written argument, Mr. Somo, you have also dealt with the merit part.
Yes, yes, of course. Everything I have. The my lord, fault of these two workmen was Prasantapura workman, respondent number 4. He came to the factory on that particular date, 3 minutes or 5 minutes late. According to him, he was 3 minutes late, and according to the witness of the management, he was 5 minutes late. He was not given a machine to operate, so there was a verbal altercation with the person concerned. This is the allegation that has been proved before the labor court. And second person who was sick on 1/9/2009 morning, suffering from deep bleeding of due to piles. He submitted a prescription, medical prescription to the supervisor that he will not be able to come in the evening. He was given an evening shift duty. And he was absent. And on the, kindly see, my lord, on very next day morning, the management sent a 5 members delegation to his home to verify whether he is sick or not.
Yes, Mr. Amat.
My lord. Just before going to the facts of this case, my lord. My land is also here, my lord. Now this part has got arguing on the merit. Assuming I got no merit, Lordship dismisses petition. Then what comes? Judgment is to pay back wages. Full back wages. Just
No, that is qualified.
yes.
That is also qualified.
Page number 125.
125 back wages, and if reinstatement not possible, compensation.
Compensation. It's all right. Say, but reinstatement with back wages. In extreme cases, suppose I lose the case. This stands. Back wages with reinstatement. We have given them an offer. Come and join. Today itself, we have given them offer. They took time. Then somehow yes or no, they said. And they ultimately, my lord, what I understand today, we said back wages, you will not get it. Because I rely on the Supreme Court decision, because they shall have to give a certificate and the affidavit in the form originally. No gainfully, they are not gainfully employed. That has to be there. So we said, why not you join here? Your promotion, benefit, pension, everything will get from today onwards. There's no problem. There they disagreed. Now, if my learned friend disagreed on that, then I go to the merit. That's why I say, shall I go to merit or he will agree to this? Lordship may clarify this one.
Where is that document on record? That document
Yes,
by
yes.
which
Last time offer,
offer.
yes. Lordship may take, this is one,
It's not on record.
not on record. But last occasion, it is in the record of the order passed by the Honorable Court. It's there. Lordship, with the order sheet, I think it is there. They took time to get instruction on that. And we also submitted. By
Order dated?
my lord. Just,
This court's order.
yes, we submitted the documents before the court. So she may kindly check that order copy exactly.
Order dated?
Might I'm not getting that date of the order.
Yes, Mr. Soma.
Instead of fighting whether they will join, we'll give them benefit, promotion, pension, everything, whatever is intended. My lord.
No, my lord, to my instruction, I asked
Ah.
I asked the person
Person got it,
concerned.
my lord.
They said that they were allowed to join, but they were not giving the back wages as per the order of the treatment, labor code.
This is an order of 28/4/2017. My Lord Justice Rishikesh Roy. DP Bora Learned Counsel submits that the management offered to take back 2 workmen in service without back wages, but they have declined the said offer made on
Yes, that is what.
3/4/2017.
So 8 to 18. 8 to 18 order.
Not so and so and so submitted the payment of back wages 9 to 13. They will obtain the problem so and so. Okay, these two are here.
Yeah. That's why I said, suppose on merit, I lose the case. Lordship dismiss my case. Then what about the instatement part, my lord? The apex court is very clear on that, my lord. That's the, in short, I want to submit that. That was. Judgment. Very good, yes. Judgment, yeah. Very good judgment. Please. দুইটা আছে, কপি দে, কপি দে। কোন পাসপোর্ট না না? কপি কই দে। আমাকে অন্য কপি দে।
It'll do. Yes, got it.
Yes, Lordship, might just take these two judgments, my lord.
লাভ নাই, মই কেনেকে চাম এতিয়া মোৰ লগত একো নাই। I provided the whole copy that I relied upon. Anyway, I leave it to your lordships, the judgment they referred, I don't have a copy, but I provided my judgment's copy to them.
That is your benevolence. So Nath is very narrow.
No, I'm not saying that. It's placing me in difficult.
It is the first day I give him the copy, my lord. UP state, and there's another one is my JK synthesis, my lord. Paragraph, Lordship is taken, which one, my lord?
UP State Brassway,
My lord, paragraph 50 and 51.
50 and 51.
Yes. It is not in dispute that respondent did not raise any plea in the written statement that he was not gainfully employed during the said period. It is now well settled by various decisions of this court that although earlier this court insisted that it was for the employer to raise the aforesaid plea, but having regard to the provisions sections 106 of Indian Evidence Act, for the provisions analogous thereto, such plea should be raised by the-
Company, that organization is a going organization, it's working,
Yes, yes.
functioning.
It's working, it's working. My lord, and then second,
What is the retirement age?
60, 60,
60.
60.
Take them back.
My lord, we are
Take them
thinking,
back.
what happened? It's not very, somehow it's surviving. Totally on their own earning, they're paying salary, pension, nothing from
Take
the
them back.
government.
Take them back. We will,
No, we're taking them back.
we will provide for something to also satisfy them. We'll work a way out. It's not 100% back wages,
Minus
But-
back wages,
but
anything, man.
something.
Minus back wages, my lord. I think
Something.
it is better for me also.
Mr. Choma,
Yes, yes.
don't
I'm
fight.
agreeable, ma'am.
Go, join.
But the
Join.
lordship will work out that the benefit they are getting.
We'll work
Except
out
back wages.
everything.
Except back
On
wages.
your increments and all. We will say it's a, they are entitled to
I don't
increments.
appreciate their salary.
They are
was
entitled to
3,000.
increments.
Increments, everything, everything.
We will give you everything.
Except
We'll
back
give you everything.
Even
Subject to
promotion.
further thought,
wages.
25% back wages. But the whole period will be regularized.
Because-
Through notional,
I don't appreciate.
No,
Their
definitely.
salary was 2,500, 3,500 at the time.
we got it.
So
Today
if
you're
that's
not
the
getting
case-
anything, Mr. Samuha. You're not getting anything. Today you're not getting anything. Forget the merit. You're not getting
No,
anything.
no, what I'm trying to say, Milord, there are enough judgment I have annexed also, which says that at least 50% they should be given. Because they were retrenched without there being any.
That you leave it to the court or the appellate court. That is a different question altogether. But this court,
What I sincerely pray.
Mr. Chamoha, this court will give you complete
My lord, no
regularization.
back wages, my lord. Myself insisting like anything, my lord. Because it's very,
No, we will give a token. We will give a token, Mr. Nath. A token will be there. This is not the way you deal with a person. We will give a token and everything will be regularized. The day you join, it will be like without the benefits, you will get the salary as if you are working
Since before.
till today. And with regard to back wages, let me see. The bottom I can go to
my lord, I've been insisting, my lord. very-
25%.
very-
minimum.
My lord.
No, my lord, 25%.
And Mr. Bora, 25%, don't pay him at one go.
My lord, they are working in a cement company, private cement company all along this.
Who?
Oh, no, that is their duty to prove that I am
That
working.
you will have to prove.
That's
No. First, they have to prove that they are
They'll,
not.
they'll give you a
gainfully
certificate to
employed
that
at it.
effect. They'll give you a certificate. You make a verification if required.
No, my lord.
We'll work out something. Don't worry.
First, my lord, they have to establish that they are not gainfully employed anywhere during this period.
We have pleaded in our,
No, no, it is not there. It is
We
not.
don't have
It
it.
is
It
not
is not
there, my
there.
lord.
It is not there.
It is not there.
I have not found out.
Where?
I'm coming.
Because
No, if they
apex
want to
code is very
argument
clear.
merit, then argument merit the whole thing, Milord.
Apex code is very clear on
There's
that.
no piecemeal, Milord. Why?
You want to go whole hog?
If they want to go on merit of the thing, then we will also go on
They
merit
will
of the thing.
benefit, increment,
Since your lord-
promotion.
since your lordship has given us a proposal, we are accepting. With regard, with respect,
Okay, Mr. Amnath, we'll consider the whole thing.
because.
In
why
terms of
they
the
are now
judgment of this
arguing
court
on this,
also,
then
ma'am.
I am gainfully.
Okay, come to the award. Come to the award. We'll see what is the error in the award. What is the error in the award?
Award page 117.
Yes, Mr. Musama, take your seat.
Now I'll just show one thing, my lord. 117 starts.
Hmm.
Lordship, we come to page 122. See the findings.
Hmm.
122. I'll just show. I said perversity. I'll just show. My lord, I'll start from the 1, 2, 3, 4, 5, 5th line I'm reading.
Hmm.
In the middle. Thereafter, Prasanna Bora was dismissed from service. Lordship has got it by 6th, 7th line. Thereafter, Prashanto Bora was dismissed from his service in such and such. Then from middle,
From
from
exhibit 2.
exhibit 2, it is found that charge sheet was filed against him for using unparliamentary words to the shift in charge of the Prasanna Bora. Exhibit 3, reply appointment such and such. From inquiry report, this is important. It is found that there is no discussion or reproduction of any evidence. My lord, please come to page 41. Please come to page 41. I'll show. This part, from the inquiry report, it is found that there is no discussion on reproduction of any evidence. Please come to page 41. Forty-one is a statement recorded in domestic inquiry and inquiry report. You also will find in page 42. For 41. 41. My lord. Please, my lord. This is the report. It says, he has admitted in the inquiry, which was unpardonable offense in the middle, first page, page 41. In spite of that, he created unpleasant situation in the mill and terrorized the environment and therefore committed a serious offense. It is worthwhile mentioning that accused person in his written reply and in the inquiry has expressed that on that day, the departmental officer caught him on chest and ordered him to go out. But when he was asked if he had any proof in his hand during inquiry, he replied, I have no evidence. It is hereby proved that accused has tried to prove himself innocent, but in vain. These are the findings. Middle. Furthermore, he was also unaware whether the red light, the symbol of workplace, was on or off. Statement of the accused that incident took place soon after the commencement of the shift is not true. Then immediately the next day, page 42, there's a meeting, gate meeting. Because of his indecent behavior, gate meeting, it is mentioned here. Then paragraph 42, last para. On basis of the personal records of the accused, it has been found that earlier too, he created unpleasant situation by violating rules and regulations of the mill. He is indifferent to the required output and has a habit of creating misuse in the mill by willfully violating the rules. This habit is against the interest of the mill.
Your basic case is it's a perverse order.
Purpose
was
order,
judgment
because time
because
come to, yes,
the
come on, proof.
admission and other part of the delinquent was not taken into account.
Page 39, please have a look once, his admission. Statement recorded in domestic inquiry. See what he has said. Start from page 37, bottom. Please come, my lord. Page 37, bottom. Question number 20. Do you sometime get late in coming to the mill? Yes, sometime I get late. If the dependent is asked you about the cause of late, do you show cause? Yes, I narrate. When the officer asked about the cause of late on 19/6/20 day of incident, but you replied that sometimes it may be late. Did you show any other reason about this? Yes, I was not late. Question does not such and such. Read with question number 25, my lord. Now come to question 25. On that day, you joined your duties at night at right time. In such circumstances, when the department officer asked you about the cause of late several times, you got enraged at him and picked up quarrel argument with him and pushed him aside. But before arising such situation, did you inform the Sardar or other person that what you said is correct? No, I
Okay,
have to inform
Mr.
you.
Nath. Another query. Fine, we accept all these things. We accept that he is guilty. Penalty of dismissal. It shocks the
Disproportionate,
conscience.
disproportionate,
Disproportionate.
conscious.
One day incident,
What is it? It says it's the habit of, it's the habit, it says.
habit, he says, sometimes I'm late, but you have not drawn up any proceedings for that.
Even he accepted, he said, but kindly see question about 31. 31. I committed the offense, he admits.
Now, he pushed the officer to that extent, and he has given a justification for that, why he had pushed. Just in question number 30, just above 30,
30.
and pushed him.
No
Yes, I did.
evidence.
As the departmental officer ordered me to go out of the mill and push me, so I pushed him aside. So it's Newton's law, action and opposite, equal and opposite reaction.
That's why in the beginning, I said, suppose your lordship hold that lordship will interfere with this or may not interfere with this. Suppose
We'll
lordship doesn't
interfere with this. Mr. Samuha wants a decision on merits. We will interfere with the order of the labor court,
Okay,
and we'll remand back the matter for fresh consideration.
yes, yes.
Yes, Mr.
Yes,
Sukha,
my lord.
that will satisfy you?
So that back wages part also might not be looked into.
I will place my argument, but thereafter Lordship will take it easy. I strongly believe that Lordship will give you an opportunity of being heard.
Yes, yes, surely.
I think that's better.
That order is wrong. It's a perverse order. The
Yes,
order of
I-
the learned tribunal is perverse.
Also,
It has not considered many things.
my lord, may Lordship has, while in this side, Lordship has at least Lordship has appeared 1,000 meter well department against the departmental.
I don't.
At least 1,000. Have your Lordship ever seen any departmental inquiry where department did not examine any witness and the delinquent was put to question 34, 40 questions, and depending upon his answers, he has been dismissed from service? I have never come across. This is the domestic inquiry they have. My learned senior is relying upon.
Then why did you not pray before the tribunal
That
for a
is why-
fresh inquiry there?
That is why the tribunal has, what's the domestic inquiry said that
The
this is.
tribunal, if it finds that the inquiry is not proper, it could have taken evidence on
Yes,
its own.
it's taken evidence. I'm coming to this.
Show me.
Yes, yes,
It has taken evidence,
yes, it has taken evidence.
ignoring the departmental.
Yes, yes, it was saying that this departmental inquiry is null and void because of the,
Show me, where is that inquiry?
pardon me,
Where is that inquiry proceeding before the tribunal?
no, the evidence your lordship is asking.
No, 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 in the order,
Award.
in the award where it is reflected.
Yes, yes, it will be written in the award only. Award is a judgment, that is 117. Where it is said that the whole departmental inquiry is false. They did not examine any witness, nor I was given any opportunity to cross-examine anyone. They put me questions, 34, 40 questions, depending upon my answers, they dismissed me from the service. Is it a domestic inquiry? And they're asking, they're saying that they'll give me nothing for back wages. In my respectful submission,
Mr. Nutt, is the situation correct, understanding of this court correct, that the domestic inquiry was held to be bad by the tribunal and then it proceeded on its own to examine the merits?
yes,
No,
Where?
no, that part is not there.
Where? I don't
No,
find it.
no.
That's why I'm asking.
No, my lord.
then why is it examination, cross-examination in the labor court?
Which one?
It just started here from my lord.
No,
Lordship,
in the order.
if I am
in the
allowed
order.
to start in my continuity, my lord, then I will show to you, lordship. But see, these are the whole departmental labor court proceeding starts from, my lord. It starts from page 72, annexer 3.
72.
Ah, yes, annexer 3 of the writ petition.
Hmm.
Affidavit by management witness 6, Sri Anupam Chaudhary.
Hmm.
This is the person against whom the allegation is that I pushed him.
Hmm.
This is the evidence before the labor court. And he said that I pushed him. Now kindly see his cross-examination at page 74. May I read, Miller? Then management witness, another management witness, Milord, Kulendu Das, he is the inquiry officer, domestic inquiry officer. He himself admitted that no opportunity was given, no natural justice was followed. He himself admitted, page 78. Then Milord, MW8, Sri Ravinder Kumar Sharma, he is the departmental officer who dismissed me from service. Then from MW8 onwards, Ravinder Kumar Sharma, page 83, cross-examination. He admits nothing was followed. MW9, Gokul Bora, cross-examination at page 87. He said, I have no personal knowledge. If they go on, I have to read all this to you.
Page 124, it says, no proper procedure followed in domestic inquiry. Page 124, it is there. Page 124.
But that is again substantiated by the evidences that have been brought on record in the labor court.
Anupam, he took a U-turn. On what basis, I don't know. After 3 to 3 years.
However, no proper procedure is followed at the domestic
yes.
inquiry.
There was no fresh inquiry done by the tribunal. It only relied upon the inquiry of the
No,
domestic inquiry.
No, my lord, kindly appreciate. These are the written evidence. Evidence on affidavit.
Mr. Pamua, the tribunal can on its own examine the charge if it finds that the domestic inquiry is not proper. It has the power. That power has not been exercised.
I kindly appreciate then why this evidences. These
Evidences are for justifying the departmental inquiry, the domestic inquiry, and they have not been successful. Okay, fine, got it. When, give me a small note on
I
your,
prepared that.
no, that is not covering all this, what you are arguing, trying to argue now, what it has developed now. Show me the lacunas in that inquiry before just give me a 2-line statement of the,
Assuming I admitted, even I said, my lord, minus back wages, that's the reason I say. Supreme Court is very clear on that points, my lord. Not gainfully employed, my lord. Forget no back wages, take everything else. That's the reason I said very first day.
I have not understood what my learned senior friend is saying.
Yeah, that's so.
you did not understand.
No, my senior friend is saying that we are ready to accept, but will not give back wages. The record shows not.
I am not saying, it is Supreme Court says, my lord, don't give
The
back wages.
record says, well, there was no proper domestic inquiry. I was retrenched. Then matter went on labor court, then high court.
No, we have found our way out. We'll pass out. We'll put you back in service.
Pardon?
We will interfere with the order of the labor court. Or sorry, we will uphold the labor court order. Say that the domestic inquiry was not proper. We'll direct them to take you back. Back wages up to them.
Back wages.
You will be Reinstated, don't do it.
But they would have reinstated me, I would have accepted, then my lord, I sincerely pray, my lord, to hear me on merit, my lord. When there is,
We are dismissing the writ petition.
I understand, but if
He should be
give them the
happy.
leverage to decide on back wages,
We'll give them a leverage. We'll give you a liberty approach.
this will not do, my lord, kindly appreciate. This man is beyond, kindly appreciate one aspect. My lord, I'm not criticizing anybody's judgment or any court's judgment in a very constructive manner. Kindly appreciate. One
2009, that offer was given to you.
offer was given of
one thing,
reinstatement, Lord, kindly appreciate.
One thing,
They
Mr.
were not giving me
Samoha, the offer was given to you in 2009. Reinstatement. This court did not disclose its mind at that point of time. Matter was pending. You could have taken that opportunity, gone back to your job, leaving it to this court to decide at the final hearing. We would have been with you.
My lord, these are labors. my lord.
That shows you are not interested.
No.
That
no.
shows you are
No,
not
no,
interested.
Unofficially, he is
Kindly-
engaged in
kindly-
cement company,
kindly
unofficially.
don't observe, kindly don't give that observation because these are the poor persons running from the pillar to post.
You
for
were
one small
a
meal, Lord.
knowledgeable counsel assisting them. Why did you not advise them to that extent?
No, my lord.
Why did the council not-
Second one in queue.
I'm
Lord.
not, whether it was you or somebody else. The
Maybe,
council was
maybe,
there.
Maybe.
Why did the council not advise?
That is their council's fault.
You
Why
can't
they should
say that.
suffer? Why they will suffer, my lord, for the fault of the
Who?
council member? Why this?
Ask
poor
them to
people-
proceed against that council.
No, my lord will bring out a practical solution to the whole thing.
I'm bringing out a practical solution.
No,
I'm
lord,
putting you back into service.
they are already, they have offered. We did not accept because they are not providing us the back wages.
So we'll provide that. You don't go. You don't go. How you are continuing today, continue. Till another how many years more? 40, 46, 14 years more. Continue. Don't go.
Actually, Solto is getting the evidence that cement company. He tried his best, but could not. They're working cement company. That's why they're not joining.
But which is
The
not
actual
on
fact is
record, we
that-
should not.
That we will
argue.
not take.
No, I'm not saying.
Which is not on record, we will not.
We'll
argue.
not take.
Not on record.
We'll pass orders. Don't worry. We'll see to how we can help you out the best way.
My lord,
But your conduct
have
somehow is
I
not.
have strong confidence and belief on your lordships, my lord. And domestic inquiry, my lord, I have never seen.
I
this
am
kind of-
saying, I am satisfied. Mr. Nath can bring in 100 judgments. As far as this court is concerned, writ petition dismissed.
I'm obliged.
Applies, my lord.
Heard
First
the parties at
time I'm
length.
feeling so happy after this of the petition.
Heard the parties at length.
Wonderful.
List this matter again on 7/5/2024 for delivery of orders.
Applies.
I'm obliged.
If you have anything to
I'll give
add,
in writing, my lord.
back wages judgments,
I've
Anything?
given all the back wages judgments are there.
but we are interfering, don't worry. Mr. Nath's case is going.
7-5.
No,
Why not? 7-5 fixed it.
7/5, we'll pass
Prosecutor
orders.
going to cast vote.
Oh, no, sorry, 9/5.
9.
No. 8/5. Sorry.
7/5 is
8/5,
holiday.
sorry, 8/5.
The only sincere prayer, my lord, lordship will go through my written argument once, my lord, just for a second.
Do you
I have
think,
given enough,
why do you have that view that this court will not go?
I'm just praying.
No,
my lord.
why do you have that view that this court will not go?
I'm just praying, my lord. I'm just praying. My lord. I can definitely pray, my lord.
Mr. Sumwa, we have gone through that part. We found what we wanted. That's why we have closed the matter. Yes,
That this matter be taken after some time.
didn't have breakfast in the
Yes.
morning.
That this
Have
matter,
you had breakfast in the morning? Then your sound is not coming.
let this matter be taken after some time. The council is in another court.
Consider heard the matter and concluded for judgment. They wanted to submit the record. It's
Sound क्यों आ रहा है? Sound तो आ रहा है. Sound hard, I can't. Yes, Mr. Sumi.
On the earlier occasion, Lordship had heard the parties
Ah,
and matter was fixed only for production of the record.
records.
Right.
Mr. Chakraborty was supposed to produce the records. Mr. Deori, you have the records with you?
Yes.
I think we wanted to verify the manner in which the evidences and all were taken and the records are here. The penalty is dismissal.
Dismissal for some. I had only argued that on the basis of the doctrine of proportionality, that it is too excessive. The incident basically, he has failed to be on DP on a particular time on 2 occasions. First one, he has explained that phone call was received by his son. And the second one, he said that as he had to come by cycle, so he was late. The
He went
evidence,
by cycle, so it was late, huh?
he was
And he got the information sometime in the morning.
in. And the command certificate also, my lord, possess the same.
Mr. Suikya,
Gotcha.
help us out. We'll ask Mr. Deori to give you access to this. Just mark the relevant. And just also find out one thing for me. They have taken note of your past misconduct. Now, whether that at any point of time was brought to your notice or in what manner it was brought into the inquiry proceeding.
Gotcha.
If you can just find
Yes.
that out.
There's several proceedings earlier which were concluded and the punishment were.
I'm not on
inflicted.
that. If
But
they
there-
want,
There's one or two proceedings
which have not been concluded.
which has not been concluded.
Forget, let us give them that doubt, that even that can be taken into account. But they'll have to, it was in the show cause, it was not there.
It was not there.
So somewhere they'll have to bring that aspect into notice for the purpose of determining the quantum.
But for that matter, that one judgment is there when it says that since no evidence is to be laid against that particular charge or whatever, because it is already a concluded proceeding, only for the purpose of passing the punishment, that has been taken into consideration. In that case, mentioning of those the proceeding may not be necessary. That would be 2000.
Oh, sorry. It was a part of the, where is the show cause?
It was not a part of the so-called, at page 21. madam.
Okay, what do you have to submit on that?
That's it. So far as
Second, bringing in the earlier charges.
Look, so far as the other concluded proceedings, I have nothing to say, madam, because already punishment has been inflicted, whatever, madam.
But that can be always taken into account for determining the quantum.
Look,
There is no dispute on that.
business,
Your case is first, they'll have to prove the charges that are there against you.
look,
Then the other part will come.
then other party.
So charges are proved.
Look. And the two of the disciplinary proceedings which were ongoing.
No, they have taken that,
they
there are
have
two
taken into
pending.
account. That they could not have, madam, taken.
Will not materially change it because they have said that there are two pending against you. That will not, neither here nor there. But the other things that they have taken, I think that is enough.
No, but then your lordship will see the maybe, my lord, 5 or 10 proceedings where there are some of the including reduction to, my lord, in scale, etc., my lord, has been punished, my lord. But now the present two charges, no contrary, my lord, has been come up or nothing has been come up in the evidence that he was informed prior to, my lord, the first, my lord, detailment, my lord. And he clearly says, he admitted he was late, but the reason he has, my lord, there's no intention to, my lord, avoid the, my lord, duty that has been enshrined. The phone call was to his son. Son has reported him lately, so he was late. And the second occasion, he said, morning I received and I had to come by cycle, so I was late. But then authority has taken, my lord, to the note of the command certificate, where it clearly, my lord, the timings are totally different. 6 and 6:30, whereas, my lord, the command certificates were issued, but there it is mentioned 7 and 7:30. The exhibit 1 and 2 there. So at least, my lord, they may rethink for, my lord, giving any other, my lord, proportionate, my lord, punishment, my lord. Otherwise, my lord, there's other many flaws there, my lord, including non-appointment of presenting officer, etc., my lord, and other grounds. But then even the inquiry report was also not supplied. But then these were not the grounds in the appeal, my lord, and not ground in the present writ petition also. So I am not going into that, my lord. So only on these two counts, if matter can be remanded to, my lord, rethink on the quantum of punishment. I have cited a judgment also, my lord,
That Supreme Court proportionality.
Lordship,
AIR 2010 Supreme Court,
Lordship, 75,
75.
paragraph 26. They are absent from 6 months, my lord, from duty.
There was a similar case in Bornachal when I was sitting there. They had a charge fresh and they had a second charge for past misconduct. Therein on examination, this court came to a conclusion that the first charge is not proved. Naturally, there was no material to prove that. So we said that basing on the second charge, you cannot impose any penalty. It is only when the first charge is proved.
That only.
As a consequence of that, for
Second.
determining the quantum, you can bring it in.
Exactly.
Independently, you can't have it. And I don't think so. I don't know whether it's an appeal has been prepared or not.
Here also, you'll also will find, but the documentary evidence that will prevail over the oral evidence, the documentary evidence, that is the command certificate. It gives different the timings. And the authority has taken note that none of the witnesses have said they have the delinquent was seen at the place. That is the observation of the inquiry officer as well as the disciplinary authority.
In your inquiry, you have said that you have used the word Obahala Korana. Okay, let's consider. Mr. We are just retaining this records. Mr. D. Durilan, junior government advocate, has, in terms of the directions passed by this court, placed furnished to the court the records of the inquiry proceeding held against the petitioner herein. Also, hearing concluded, list this matter again on 2/5/2024 for delivery of orders.
Wait, please, my lordship. My lord,
Who is opposing you, Mr.?
Mr. Biplab Sharma, my lord, he has just informed me that he is engaged in another
CGC.
court, my lord. Yes, my lord. He's engaged in another court, my lord. He has sent a message to me, my lord.
As the learned CGC is not present and is set it to be on legs in another court, list this matter again on 14/5.
Bless you.
Yes. Anything more to add?
Well, my submission will be, my lord, there is a note, my lord, that it was condoned, my lord. Nothing beyond that.
You will make, you will submit to the extent that that note should be, contrary not being proved, that note should be taken into
No,
on
not
its
just
face
that.
value.
Not just that alone, my lord. Lord, I'll be relying on some decisions, my lord.
Hmm.
Where, my lord, the suitability of the person concerned, my lord. Here, what has happened, there's a note, my lord. The records which are called for, my lord, were called in much, my lord, I think, my lord, this records were called for, my lord, in 2000, my lord. A few years back, my lord, 16, my lord, or 19, perhaps, my lord. Now, my lord, at that point of time, I don't know what records were actually called for. Now, what has happened, my lord, that they have produced a record which shows, my lord, there is a note, my lord. At least there is a note to say that, my lord, the appointing authority has condoned the delay, my lord. So therefore, in my humble submission, my lord, there, my lord, if there may be other records, I don't know, my lord, of course, I'm not very sure about it. It's for the government to say, my lord. But that per se, my lord, that note, since the note is there, my lord, that per se is not an irregularity or an illegality, my lord, we should the entire proceedings, my lord.
At best, it's an irregularity.
Irregularity. And my lord, the person, my lord, if you lord.
Give me the judgments.
Yes, my lord. One is, my lord, 1997 6 SCC, my lord. 614. I'll give the copies of the judgments also, my lord.
Para?
My lord, I'll just. My lord, here, my lord, it is para, my lord. 11, my lord.
Hmm. It's okay, just give me the citation.
Yes,
That
my lord. My lord, here the relaxation, my lord, is to be, my lord, exercised in public interest in a given case. For example, if the other suitable candidates are not available for the post, or the only candidate who is suitable has crossed the maximum age limit, and to mitigate the hardship in a given case. So, my lord, here, my lord, my submission will be, my lord, this particular, my lord, respondent number 9, my lord. The private respondent, my lord, he was, if your lordship looks at the selection process, my lord, he got much higher marks, my lord, about 90%, my lord. There is a, my lord, physics, my lord, there is an examination machine test, my lord. There also he got much higher marks.
this is a two-edged sword.
My lord.
Be careful.
Well, there is another, my lord, another judgment, my lord.
Mr. Doctor, this can go against you also.
Well, here, my lord, my submission will submit, my lord, augmented another judgment, my lord, which, my lord, this, my lord, where is there, my lord, that. Here, my lord, I would submit, my lord, that the candidate of your lordship, my lord, was selected, my lord. He was otherwise, my lord, he got much higher marks, my lord.
Mr. Doctor,
My
last occasion I told you, that is inconsequential. I think it's better you don't show me anything.
Well, the other people,
Yes.
that, my lord, I'll be relying upon, my lord, that since almost 10 years have passed, my lord.
Okay.
This
Well,
person
yes.
is on the verge of retirement, my lord, 3 years left, my lord.
Yes.
There is a well settled, my lord. If a thing to be done in a particular manner, my lord,
It's not done in the Nazir.
my lord.
Too late in the day to address that issue.
Well, I am in second position also, my lord.
Hmm?
I am perusing, go through the record, my lord. I am in second position, my lord, here.
I got it. He is there for the last around 10 years now.
But, my
Right.
lord, no specific order, my lord, that, my lord, the age is condoned, my lord.
There is a note. We tried. There is a note. that the age has been condoned. Rightly, wrongly, at that point of time, they did it. And once he is in, your only contention was that.
my lord,
I think you had two contentions. One was the position before the corrigendum, right?
my lord,
And that has been now clarified that there is a corrigendum issued and the corrigendum also brought him on into par. The corrigendum is not under challenge,
my lord,
right?
my lord,
Second is the overage.
over it, my lord.
Something is there on record to show that he was otherwise condoned. He made an application and the appointing, we didn't like the manner in which it was done.
My lord,
But that's our liking is different. There is something on record. Not in this case, some other case. We will
kindly
try
see,
to.
my lord, kindly see there, my lord, affidavit in opposition, my lord, filed by the respondent number 5. Paragraph 4, my lord. They have, my lord, stated in middle portion, my lord, in page number 40, my lord, 40, my
Whose
lord.
affidavit?
My lord, filed by the respondent number 5, my lord.
5. Okay. Paragraph?
Paragraph 4. They have explained, my lord, regarding the, my lord, the convention delay, my lord.
Okay. Anything more, Mr. Counsel?
They said, my lord, they see from the report, my lord. They stating, my lord, here, my lord, middle person, my lord.
Okay, fine. That is the record. We got it. At this late stage,
My lord.
dismiss. Mr. Doctor, judgments we are not referring on your part.
Oblige, my lord.
I pray for time being, take some likes.
Not today,
For some
some
time.
other day. This is with regard to that accommodation.
My lord.
Yes, what do you have to say?
Lordship, my senior is saying.
Oh,
this
both of you.
matter.
On the prayer made on behalf of the Learned Council for the parties, list this matter again on 13/5/2024.
In this case, Lordship, during the pendency of this case, there are certain developments. May I like to file some additional affidavit, Lordship?
2014 matter. Why was the affidavit not filed till now?
Additional affidavit, Lordship. I have no information, so I have recently collected the papers from my client, and government has also not contested the case.
Okay, that matter. Because of an earlier order of this court, your services were supposed to be interfered with.
Yes.
But you are continuing in service till date?
And the respondent number 5 is also continuing.
In service. And there were vacancies available.
Available.
And there is an interim direction passed by this court. We will close the matter in terms of that. Who is appearing? Get Mr. B. Gogoi. Get Mr. B. Gogoi, we'll close the matter.
Chief may pass word on matter for the time being. Wait, please, your lordship.
Yes.
Lordship, the petitioner before your lordship is a constable, my lord, general duty, who was appointed in the year, my lord, 2002, my lord. On the
Medical report.
Yes.
Medical report that day, then there was a appeal.
Yes.
What is the error?
My lord, after that, they have rejected my claim.
Oh, naturally. They have rejected it and they have justified that in their affidavits.
But The thing is that, my lord, they may have adjusted my case in any other vacancy.
No, they cannot.
My lord, kindly. peruse the-
Because the provisions of the PWD Act is not applicable. It's exempted organization. It's an exempted organization, Mr. Councillor. Show me
But my
that
lord,
PWD Act
annexure-
is applicable to the
my lord,
forces.
kindly peruse Annexure F, my lord.
Annexure?
F, my lord. My lord, here the medical.
Page.
Page 27, my lord.
Yes.
Dated, my lord, 2 August 2013, my lord.
Hmm.
My lord, here, my lord, medical board, my lord, says that, my lord, I may not be fit for combat duties, my lord, but I may be adjusted in.
No,
general-
you were recruited for a particular job, Mr. Council.
Yes, my lord.
And it is not a case that because of the service injury,
Yes, ma'am.
you were disabled.
My lord, during the-
Section 45, I think, of the PWD Act,
Yes,
you will have to be accommodated in any other thing.
Yes.
Unfortunately, that act is not applicable here.
That is true, my lord, but one more thing is there, my lord, I would like to submit before your lordship, my lord. That is, my lord, it was the legitimate expectation of the petitioner, my lord, that after being selected on a rally which was held by the respondents, my lord.
Are you disputing that recruitment process or the medical examination that you are not fit for, to the extent that you are not fit for combatized jobs?
Yes, I'm not disputing that.
Then
My only.
very fair on your part.
My only.
Thereafter, what is there, Mr. Council? And see, another thing, let's be practical. You were around 30 years on that day. 30, 31 maybe.
30 years.
Today we are another 10 years down the lane, 44. And
My
you
lord,
are
Petitioner is 40 years old, yes, my lord,
today.
yes. Ma'am.
So how can I force them to take you today?
Then whatever your lordship may deem fit, my lord.
Sorry, next time. Sorry, dispose of.
Deeply obliged. my lord.
Who is appearing for the respondents?
KK Parasar lordship.
KK Parasa.
Deeply obliged.
And your name?
As Upadhyay, my lord.
S. Upadhyay.
Upadhyay.
S. Upadhyay, Learned Counsel for the petitioner, and Mr. KK Parasa,
KK Parasar.
Learned Counsel, CGC, representing the respondents.
Deeply obliged.
Obliged.
I have applied my mind. I have gone through it, but sorry. Do affidavit file, Mr. Mondal?
My lord, they have,
They have filed.
yes, they have been instructed. I have received the instruction.
If he is having 40%, why are you not giving it to him?
No, true, ma'am.
Then give it. If he is having the benchmark disability now,
My lord,
then
some mistakes is there. My lord, actually.
rectify it.
Third party has done that mistake. My lord. They have.
Whoever it is, now it has come to your notice, why it should a person suffer? Give him his appointment, we'll fix the matter on first.
Should may dispose this matter directing the
Huh?
authority lordship may dispose this matter. My lord.
Okay. Okay. Dispose of, we'll pass on this.
Obliged, sir. Obliged, sir.
Ojwa Kalendri. I'll enter another resident.
My lord, my senior is in the another courtroom.
Yes,
My lord, we have not received any other instruction. My lord, matter is under process.
you undertook that today, that's why the matter was listed. What is this fun?
I have received just. My lord,
Yesterday, your submission was to take the matter today,
my lord,
after some time, then it came to today.
my lord, I know that, my lord,
Huh?
The matter is under process, so my lord, I leave it to you, lordship.
No,
We
no,
can-
how can you leave it to me? You were you had undertaken that you will give me that instruction. It is in your instance
At
that
this
you,
moment, we cannot do anything, my lord.
why?
Sir, all are
Ask your secretary to be here at 2. We'll ask him.
today or any other day.
Huh?
Today or any other day. Secretary.
Today, 2 o'clock. This poor, 2 hours are there, he can reach you.
At 2 p.m. I have
2
some
p.m.
difficulty.
Ask somebody else to be there. 5 dates we have been accommodating. And this letter was given on 30th March. You told us that this is done. And still, nothing is being done. Have you contacted the secretary?
No.
Who?
My lord.
Who has contacted the secretary for instructions?
And for
Mr. Chisti, what is this? Last 3-4 dates, only we have been adjourning the matter saying that we'll get the instructions.
Yes, Lordship, some instruction has come that matter is now pending.
That is
That
too
is-
old.
But process is going on, Lordship.
That's we
Only
wanted
because
to
of
know what
this-
is the problem, why it is not being done. That much only we wanted to know.
Only because of this, Lordship, that code of conduct. Lordship,
Code
I
of
think,
conduct came the other day.
other day.
This
Otherwise-
first order was of 1-4,
2-2.
5-4, 22-4. And before that,
Otherwise, Lordship, the
14-3.
department is positively considering this case, Lordship. And now it has been forwarded to the
2-2.
government, Lordship.
See, Mr. Our first order is 2-2.
February.
2-2-2024.
Yes, Lordship.
And yesterday it was listed today that the information will come. 24-3-23, the director had sent it for approval.
Lordship, kindly fix it on Friday, Lordship. Let me, I'll,
Well, yesterday was the last chance, my lord. They're not giving any heed, my lord, to the whole
even
orders of
Lordship,
the honorable
personally,
court, my lord.
of secretary, Lordship. Let me try, Lordship.
No, it's no pleasure here.
Yes, Lordship.
It will be wastage of time of this court also calling those people here.
Yes, yes, Lordship.
We don't want to have that happen. Until and unless it's true that very.
Otherwise, department is considering his case, Lordship. Only. the
Only thing is,
time
24-3-2023, a proposal goes, why a year has taken? We only wanted to know that.
Okay.
We'll have it on Thursday.
Yes. I guess, Lordship.
On the prayer of Mr. SMT Sisti, who assures this court that the requisite instructions shall be received by him and placed before this court on the next date fixed. First off, in the event the instructions as sought for are not forthcoming, that is the reason as to why the case of the petitioner has not been provincialized in spite of being recommended by the committees as involved in the matter. The personal appearance of the secretary of the department concerned shall be ordered by this court
Yes.
for explaining as to the reason so existing in the matter, delaying the provincialization of services of the petitioner.
Apply.
Mr. Chetri, Mr. Assistant, please take some personal interest. Maybe she is not being able to communicate with the secretary. You help her out. And don't make that sad face. You be bold.
Yes.
You don't have come and tell me boldly.
Yes.
Ah.
Maybe the election. Not my lord, 1 more time, maybe granted, my lord. I asked the petition number 6, my lord, to come and file an affidavit, my lord, regarding his earlier case, my lord.
Why was this affidavit not filed?
I asked the petition number.
Last time also you said you will be filing, you did not file. 8-3, we had made this observation. 8-4, matter had come up. and adjournment was taken. Before that, on 27/3,
Next week, madam.
Friday,
Friday,
Monday,
Monday, madam.
on the prayer of the Learned Council for the petitioner, this matter again on 29/4/2022. In the event the affidavit as required to be filed in the matter is not filed, the court will proceed with the hearing of the case basing on the materials available on the court.
Madam, obliged, madam.
Yes, Mr.
My lord, in this case, my lord, my defense is for non-provincialization of my case, my lord, as a social science teacher, my lord.
Mm.
Here, my lord, three persons have been incumbents have been provincialized, my lord. The two belongs to the language stream and one belongs to the science stream, my lord. So I have said that, my lord, because depriving me, my lord, two language teacher could not have been provincialized, lordship. In a nutshell, my lord, this is the case, because otherwise it is an admitted fact, my lord. That yes, I belongs to social science stream, my lord. An affidavit has also been filed. And if your lordship kindly look into my lord, the proposals for provincialization, there my lord will find that also, my lord. I'll take your lordship to page 36, my lord,
36.
of the writ petition, and my lord, page 37. Yes, 36 is the, my lord, it is the proposal for, my lord. My lordship will say, I am Sajan Ali, social science teacher, and
Who have been provincialized? Abdul Batan.
my lord, one is Abdul Batan, and another is Ayesha Khatun. She is Arabic teacher.
And one more, Rakibur Buksing. Science teacher.
He is science teacher, my lord.
Okay.
Yes. And if your lordship look into page 37, there is a letter, my lord, I forwarded here, the application only submitted by the science or science for both.
Your date of joining was taken as 2015 by the
My
government.
lord, that is the
Error.
mistake apparent from the fact of yes, it is admitted by all of them, my lord, that I appeared in 2005 only, my lord. The private respondent.
Where is
also
the
admitted.
affidavit of the private respondent? Yes, respondent number 6.
6 years already filed affidavit, my lord. Respondent number 5 is also filed the affidavit. 6 affidavit का कोई. Now 6 affidavit filed by my lord respondent number 6. Huh? 5 is the headmaster, 6 is the private respondent.
So that is your case, Mr. Ghosh. Nothing more. That is your case.
That is my lord. I also take much time, your lordship.
Yes, Mr.
But, the first ground I have taken, there is a provision of statutory appeal under section 14. That is
Accept.
paragraph 7 and 8.
Accepted.
My lord. Second,
Go.
paragraph 9, my lord, last paragraph
Of
of my affidavit, my lord, page 49.
paragraph 9.
Yes, last paragraph. Paragraph 9, my lord. My lord, what I have taken the plea is the madrasa. It is a girls' madrasa, ME madrasa. My lord, at that age group of the girls,
A lady teacher
A
is.
lady teacher is required because that is the age group. And my lord, another interesting thing your lordship will recall, my lord, unless and until a lady teacher is shown, the school is not regularized. School doesn't come under the regulation. If it doesn't come under the regulation, question of provincialization doesn't come. But in my last paragraph, I've taken it that there is no conflict between the petitioner and the deponent because
You are the only lady there.
yes, I'm the only lady there. And the petitioner is a social science teacher. Therefore, I did not occupy her seat. It is admitted, my lord. Why she was not appointed is not known to me. But if we
But
take,
Mr. Abidin,
if we take only one thing, my lord, I'll
Abidin,
just,
the thought process, the legislature while formulating or enacting the Act of 2017, naturally
yes,
had known that this is the situation.
Yeah.
Why did it not make any provision to
my
that?
lord, I think because if your lordship
When
realizes
it's not there in the Act,
No, it's
can a
not there.
delegate?
my lord, is not there. If your lordship recalls one thing, some copy paste were made from the RTI, my lord, RTM.
That is not a ground.
Yes, but what I'm now, I'll take my.
So you also admit that he is a social science and
Yes,
you
yes,
are.
yes.
Anything more?
Only one thing I'll say, my lord, page 53 would your lordship may come to my,
53.
that is the district scrutiny committee's report. My lord, one thing I think this side from the government, they are sitting merrily on one ground when the school is initiated to be with the base school. That people-teacher ratio is not maintained and it is not argued also. Now, my lord, if your lordship comes to page 53 and page 53, my lord, see the number of existing students in the base school. 252, your lordship got it. And number of existing in the newly provincialized is 81. Now comes to the next page, my lord. Total number of existing teacher in the base school is 5. My lord got it. Now they have taken 3 from the new provincialized school. Though their recommendation is 4. If your lordship comes back to page 53, your lordship will see that first column that there are 4 teachers.
What is the ratio? 1:30?
1:30.
You
So
come to that.
ultimately 11 numbers of teachers required.
No. You come to that PTR.
No, I'm not talking about what I'm saying. If the school is at the time of provincialization is taken to be with the base school, then the ratio with the base school comes.
No, it will.
Yes.
The base school concept will come after the provincialization.
Over here, in the some schools are provincialized with the base school.
The base school is also provincialized.
Yes, yes.
It's a provincialized school or it's been provincialized together with the school.
No, it is an existing school.
Then?
But what I'm saying, if your lordship looks at the page 53.
That is a good ground. If we say that your provincialization is bad and he ought to have been given, we will also provide for an appeal provision to you to approach the appellate court.
No, what I'm
and therein take all this, please. Then come back to us.
No, what I'm saying, page 53, if your lordship takes up once.
It's with me.
There are 4 persons have been.
Mr. Abidin, come back to page 54.
Yes, madam.
PTR after amalgamation 1:30.
Yes.
Then
After amalgamation.
after amalgamation 1:30.
Yes.
It's met.
No, it's not met. Is 11 is required.
No, from both the schools together after amalgamation, last column 1:30.
Yes. That is the reason 11 is required. They have got only 8. That's what I was pointing out.
PTR after, come to that. PTR after amalgamation of the newly provincialized school with the base school.
Yes,
10 plus 11, 1:30.
Yes. Then your lordship see the student 252 and 81. So automatically more than 10. It's 330 around. So it has to be 11. That is the
Total number of existing teachers of a base school, 5.
Five.
Total number of teachers of newly provincialized school,
Three, they have
eligible
taken.
for provincialized so and so, 11. We'll not go into that. Anything more?
I'll only,
Is there an interim direction in this case?
Yes, my.
yes, interim direction, my, though I'm
Yeah.
working, though I.
No salaries.
No salary.
Interim, well, they paid, they filed an application for vacation of the order, that petition was dismissed, my lord.
Okay,
So,
that
this
we know.
interim order continue.
Actually, that petition was not dismissed. That was said it will be taken up along with the.
No,
case.
my lord, there is a
Yes, that
specific
was-
order.
My Lord Justice Soikia's order.
No, I think Mr. Burua's order.
Justice Boga's order.
Devasis Borua's order.
Yes, yes.
The Lordship, my Lord.
They were
Stands
to-
disposed of.
Yes.
Then it says it will taken with,
Yes,
Yes,
yes, it's not.
the issue was not, it was not on merit.
My lord, I just, one coordinate bench. My lord, para 11 and 12.
Okay.
Only one thing, my lord, I'll just lastly submit. I did not occupy his post. That's, admittedly, I'm saying it. It is there in my pleading. I do not know what is the ground he was not taken for provincialization. Only thing, he should file an appeal. Appellate authority, whatever decision is taken,
That we will provide. for.
will be taken. But my lord, only one thing, your lordship. After working for about 18 years, these persons have got. provincialization.
You have developed a very good argument with regard to para 10, 11 and 12 of that DS's minutes.
My lord, it was there long time in my mind because after.
I think
amalgamation-
that's a very good argument you have developed. I think now that has to be addressed. But we can't do it now. You file an appeal. Therein, take all these points. Let them conclude, then come back to us.
I'm
Then
not
we
in-
will,
I'm not into that at present.
you,
What I'm saying,
we are taking
I
you,
understand, I
we'll
understand.
take you
I'm-
there.
No, my lord, I understand I'm getting the hints. What I'm saying, let them file an appeal. They did not have.
You
to-
have made it. You have
No,
made your
They have not
statement.
filed the appeal.
You have made your
Let
statement.
them file the appeal and in the meantime, I should get my salary.
No,
You have made your point. We'll consider, we'll pass it at second of today. Order.
because whatever is my lord.
Mr. Ghosh,
No, I understood.
what more is required? Second of, locally filed to point out.
Taken after some time.
Not today.
Next month, code number 20. After some time.
22 matter. Can wait. You were supposed to, I think, get some. No. What was the issue?
My lord, provincialization of service, my lord.
College.
Yes, my lord. And I working as librarian, my lord.
I think I heard this matter the last day. No, last day it was
Yes,
for
sir.
orders.
Yes.
We had fixed it for, okay. Why was your case not considered?
My lord, they are rejected, my lord, underqualified dimension.
Okay, we'll take it up after some time.
Yes, my lord.
Also, there was any other one part of matter. I had
Okay,
fixed loss-
on the prayer
Code
made
number
on behalf of the parties, list this matter again on 13/5/2024.
loss, obligation loss.
But I think you will have to give him a consideration and then
Lordship,
consider his case in that scheme of the act. And then come to a conclusion that he is not
2017 lordship, his case will be considered.
considered, 2017 only. Consider him and then come to a conclusion, communicate that.
2017, we have no objection lordship.
That's what I said, we can
But
dispose of the matter.
He paid for 2011. That
11
cannot,
you are not going to give.
that cannot be lordship. 2007.
10/4 is not satisfied in your case. We are consistent on that.
Lordship.
If you want 2017, we will pass it over. We'll pass that order. Mr. Gogoi will also not have it.
2017, we have.
Mr. Gogoi need not be here. We'll record your name. You get that instruction.
My lord, my senior.
You get your instructions. 2 o'clock.
Yes, my lord.
We'll ask him that the case be considered under 2000,
He is agreed, Lordship may remand back the matter to the authority.
2017.
If Lordship is not agreed, then.
Then we will
Lordship-
hear.
Then Lordship may hear it.
I'll fix a date on
Lordship,
13/5.
Lordship, Lordship.
इसको अभी मत sign कराना.
All
हाँ?
right.
Right.
Vacancies in the posts had been asked for, my lord.
Huh.
Yes, my lord.
The Lordship had asked if there were
My lord, I
vacancies.
have received the instruction here,
Yes.
my lord, and in this respect, my lord, all the posts are filled.
Lordship, can I just respond on another date, my lord, because
I think we'll give it a closure. We have given you enough leeway.
Lordship, because they are telling me, your Lordship will see page.
You file an appeal, that will be better.
No, my lord, just see one aspect. Your Lordship will kindly see page number 53 and 54. These are the, there were number of selected candidates in that respect, your Lordship, in those particular categories. In page number 53 is for ST planes, my lord. Five seats were there, just one filled.
No, now that they have said that all these posts have been filled up, that's the end of the matter. Why should we disbelieve them? And we are keeping this on record. If they have said anything wrong, you know what to do.
Yes.
We'll hold them for perjury. We'll bring them here. But now that last night I told you missed the bus, but you persuaded me. So I thought, okay, fine, let's have a instruction. If there is any post vacant, we will accommodate you.
Yes.
Nothing.
But still they may consider my application, my lord, if I show it to them that there are posts or anything. Because representations I file within time, my lord.
Whenever things happen like this, there has to be certain flexibility on the part of the applicants for jobs. You can't enter into the shoe of the employer.
No.
If you are discriminated against, these courts are there. But ego, you can reach the court, but it will not take you anywhere. A grievance reaches this court, a redressal is there. This case basically hinges on an ego. I'm not going. If you had gone and then made a prayer, the whole gamut would have been different. And that's where the beauty comes. Next time, try to advise your client in that direction. Don't let them become the employer. If there is a discrimination meted out, deprivation meted out, nothing like it. But in such matters, a tactful handling is required. Because you go on a confrontation, they'll also get rigid, right? But if you succumb, join, because you're getting a job, you join there. It's not something which is in a foreign country or even outside the state. It's within the state. And thereafter you start persuading them, something will happen. But here you have lost the job. That was what was troubling me, and that was what I was persuading them. Only on that point. Today I am satisfied. We'll pass the orders in the second half.
Okay. Much obliged.
Yes, Mr. Nath.
In this matter, my lord, on last occasions also,
So
my
forget
lord.
it, you start off. If they don't want to file, how can we force them to file?
Yes, my lord. My lordship will make a
Send it for
the order.
if I have not read it back.
Our orders are very clear.
No, that is.
Yes,
there.
my lord.
That is there.
Page 40, my lord.
Lordship,
Page
here
40,
it is.
lordship will find the operative portion specifically directed page 43.
Hmm. 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 Hmm.
Now it is saying that, my lord, the director of BTC is not authorized to allow me to join. Now it is the Assam, my lord, director Guwahati Kailipara. Now I am within their jurisdiction. So Kaile, that respondent number 2 was given many operations to file their instructions and affidavit.
Last occasion also they did not. So my lord, my prayer is that petitioner may be allowed to join, to direct the respondents to allow him her to join. And also, I prayed for my salaries back, which is.
Yes, Mr.
Lordship, here the petitioner is basically relying upon a judgment order dated 23/4/2015, passed in WBC number 3625/2007. Lord.
Yes.
That was also filed by the petitioner. Lord.
Hmm.
In that case, Lordship, if the judgment was relied upon, that is 579 of 2007. Lordship. Lordship, that judgment was relied
Then it
upon.
was taken up on appeal. That judgment went up on appeal.
Lordship.
And appeal, there was a undertaking given that some policy, whoever got salary till a particular date would be reinstated.
But my first submission will be, Lordship, the facts in that case, Lordship, and facts relating to the present petitioner are different.
Okay, fine. This order, how can I go beyond this?
No, Lordship will go to the other judgment also, that is 579/2007.
This court, when it says
No, Lordship,
that
a
it
judgment was passed. This is order dated 23/4/2015 is there. This is not an executing court, Lordship. Alleging non-compliance of this order, one contempt case was already there. That was disposed of. A stand was taken by the BTC authority that we are not responsible for giving effect to the complying the order passed by the honorable court.
Why?
Because that is the reason, Lordship. That is why I have brought the other judgment, Lordship. In the other judgment, Lordship, all the petitioners were appointed by the BTC authority. Advertisement was issued by the BTC. But in the present case, Lordship, it was the advertisement issued by the state government. Appointment letter was issued by the state government, terminated by the state government, Lordship. If an order is passed to the BTC authority, reinstate them. Wherefrom I will comply that order, Lordship. How can I comply?
What is this 23/4/2015? Okay, the earlier one.
Lordship.
No, it's on a different footing altogether. You come to page 47.
Lordship. Lordship, here Lordship will see.
Here, you did not receive any representation. For that, you were not in a position to consider.
Lordship, may kindly see page 46. Page 46, last paragraph. The Director of Education, BTC, has filed an affidavit in opposition wherein, in paragraph 7, a stand has been taken that the authorities in the BTC had not received any representation from the petitioner for carrying out the needful. A stand was taken. The said stand of the Director of Education, BTC, has neither been controverted by the petitioner by filing any counter affidavit, nor the petitioner has appeared before the court to address the issue. Accordingly, the contempt was closed.
No, where do you get that?
Page 46 and 47, Lordship.
Okay, 46 second paragraph.
Last paragraph, Lordship.
Consequence of so-and-so, so-and-so, so-and-so.
Last line, the Director of Education.
Just a moment. Consequence of interfering with the order. Interfering, how come the order is interfered with?
Page 46, Lordship. Page 47, it's an order by the
It is
honorable.
provided that the order so-and-so being set aside, consequential steps be taken. Requirement of the order. So the second line is wrong. The consequence of interfering with the order dated 23.
The lines.
That's a typographical error.
It's the last line of the
No.
page 46.
Come to that second paragraph. Consequence of interfering with the order dated 23/4/2005. It should be 26/12/2006.
Lordship.
On the ground of the authorities in so-and-so did not have any role to perform would now be considered and given by BTC as the petitioner not for doing. We have did no, so this is on a different technical issue. Naturally, he did not appear
Yes, my lord.
before you. How can that judgment be set at naught?
Thereafter, Lordship will find,
come to the
thereafter,
next
page
Lordship.
48, my lord, page 40.
Yes,
Lordship will first see the advertisement, Lordship.
Mr. Counsel, I'm not going into that.
That is not.
When there is an order, He filed a contempt. The contempt was dismissed on a technicality that he did not submit a representation to you. That right that has been set at rest by that order,
Yes.
that cannot be taken away. That will
There-
remain.
Thereafter, I filed representation and they have come with the.
So
now
how
the
can
new-
you now? And even if I read this contempt order, it says that you are to do it, but he did not file a representation, so you cannot do it. It's not the other way around.
But at that point of time, the representation was not before me. In the affidavit also instruction I have received, Lordship, there is also, it is the stand of the BTC authority that nothing in respect of the petitioner is to with the BTC authority. Because the advertisement was not issued by us. Appointment letter was not issued by us.
That is not the point.
No,
That
inquiry
order,
was-
that order still stands.
No, but Lordship will see it
Who
that.
has given past this order? We'll come back to that impugned order of this court.
Yes, Lordship. Page 41.
Hmm. Accordingly, the impugned order dated 26/12 passed by the Director of Elementary Education, Kahilipara. Where is that order?
Lordship, may kindly see the page
That is
40
my lord.
page 43. Page 43, last operative portion of that judgment, Lordship. That being the position, this court is in respectful agreement with the direction and observations made in this in the judgment and order dated 5/6/2007, rendered in the batch of petitions, the leading case being 579/2007. Accordingly, the impugned order dated 26/12/2006 passed by the Director of Elementary Education, Assam, Kahilipara, Guwahati stands was consequential steps in favor of the petitioner following the setting aside of the quashing of the order as indicated above shall forthwith be taken by the respondent
Yes, that is-
authority. But the facts are different, Lordship. If that order is relied upon, Lordship, at least some similarity should have been there between the two cases, Lordship.
And you see, that contempt order,
Lordship,
page 47,
Lordship.
it recognizes that because of the circumstances changing, see, Mr. BTC is not something which has come up independently. It has inherited
No, that is the distinction I am trying to. Lordship, in the earlier case, Lordship.
Forget the earlier case.
No, that is very
Tell
much
me-
relevant, Lordship. That is, Lordship will,
they were appointed by the BTC authority.
yes, Lordship.
But where is that plea? That plea it's not there. You will have to file a review to this. File a review, get
But
this
here
order
also,
reviewed.
Lordship, here also, no direction has been passed to the BTC authority.
Need not be, because that contempt petition this court notices, because of the change. The area now falling within the BTC area.
No, that is also my stand. That school is not within the BTC area.
Then just give us a note on that. Give us a written why an affidavit. Just give
That instruction I have.
give me an instruction from a competent authority. We'll ask the government of Assam to do the needful then. Why should we be with the BTC authority?
Even Lordship, in earlier case, Lordship.
Tell me that open that this area is not within, school is not within my area. I'm not administering it. That's the end of the matter. Yes, Mr. Nath.
Yes,
If the school is not within BTC, how can we direct BTC? Government will do it.
yes, my lord, government will do it. If he is not under the BTC, now the government, now he is beyond the BTC area, after transfer, my lord. After transfer,
When did you, where you transferred?
lordship. In 2020, my lord.
20.
Lordship will find at page, that is the, my lord, page 56, there is a certificate by the headmaster.
Which portion to the paper?
From, my lord, 25/8/2000.
That thick portion, Lordship.
Now I am serving at Bhakatpara Milan LP School under Tamulpur Elementary Block. After the joining, she has been working regularly in school, received salary up to the month of June 2006.
Mr. Come to page 30.
Lordship.
This is the appointment order, initial.
Deputy
This is by
Nalbari.
BSc,
Yes.
not BTC, BSc.
Yes, my lord, that kind.
Under BSc area,
No, Lordship, at that point of time, Lordship, it was prior to bifurcation.
Yes, my lord, that was,
BSc was created in the year 1993.
Hmm.
The subjects were transferred in the year 2003 when the sixth schedule area came up, Lordship. So area was under BSc. But the order was issued by not by the BSc, BTC authority.
the other appointments are post.
In this case,
Reappeal appointments are post 2003.
it was also an advertisement of 1999. Say 1999 year is same, but advertisement was by the BTC Lordship, BSc. And they were, along with the post, they were transferred to a non-BTAD area, Lordship, subsequently. But here, no such situation, Lordship. He was appointed by the DIO as Nalbari.
Can we keep this for the, at least till the next day, your instructions?
Lordship will allow me one more opportunity, Lordship. My affidavit is already with the authority, Lord.
Given the nature of the issue arising in the proceedings, present proceedings, full stop. A last chance is granted to the Standing Council BTC to bring on record the stand of the said authorities. Full stop. This will be elementary.
elementary.
Mr. SMT Sisti shall also, Learned Standing Council, Elementary Education shall also on the next day bring on record by way of filing an affidavit and or by submitting a written instruction received in this connection, the stand of the state respondents with regard to the issue raised by the petitioner in the present proceedings. List this matter again
In the
on-
earlier case, Lordship, 2 weeks, Lordship.
on 15/5.
Okay.
15/5/20.
Lordship.
Mr. Chisti, Mr. Fugon, please see to that.
In fact, Lordship, in the earlier case, Lordship, the inquiry conducted by the elementary education was, court preferred not to interfere with Lordship. That was even, they were only allowed to go back to the BTC authority, BTC, because the.
We'll see, we'll see.
Obliged.
Here we have received the instruction. The instructions have been received and
See, so fast. You have been granted VRS.
That is that.
Give me a copy.
I'll give you.
Lordship will observe this and will dispose of.
Second of. Second of, dispose.
That will keep the record.
No, it will be there.
In this case, madam, the affidavit of the state is elementary department is required.
What is that?
This is with regard to my lord, promotion to the post of headmaster of the upper primary schools, wherein my lord in the amalgamated, those schools where the LP school teachers having the qualifications have been amalgamated. And otherwise they are qualified and eligible, but they are not included in the gradation list. But there is no such provision.
Okay,
that they should-
argue. Nobody is there. Why we will wait for them? They are not interested. We'll proceed.
But their responsibility then.
It is submitted by Mr. B. Pukaisto that the response from the state respondents in the matter is mandated. Full stop. Accordingly, register is directed to list this matter again after the response of the state respondents is preferred in the matter.
The date will be given. madam.
Why? I don't know when they will file. Why should I keep on bringing the files? Let them file after 10 years, then you'll come after 10 years.
No, my lord, I meant that their affidavit will be required, otherwise.
If they're not interested, what will you do? If they want to file, nobody has made even a prayer. So it'll come up after.
Then we shall, my lord, proceed to dispose of them.
I'm ready. You argue. It will file it. We are proceeding for disposal.
We are handicapped with the brief. That brief is not, we have not annual part. That is the reason.
That much, at least that you make a statement. I can't on air make an, on the prayer of Mr. SMT 60 list this matter again after 3 weeks. It is expected that the respondent authority shall but before the next date fixed, shall bring their stand on record by way of filing an affidavit.
All right.
Mr. Chisi, somebody should make some statement.
There's some.
That will do for me. Mr. D. Mohanto,
My lord.
this 1015 is by you
My lord.
because that lady petitioner number 3 is no longer a petitioner. So that stay will not operate.
Lordship.
Well,
That is already, my lord, her name was already struck off by a petition, but at this moment, that was when I left out, so that may be well. I have
Continue.
already
Next.
continued, my lord.
Next. Have the affidavits been filed? No affidavit.
My lord, this is in Pranab Prasad Bharat, it is filed on 8/4, my lord.
Hmm.
And the other case, my lord, they have not filed, my lord.
We have filed into both the cases.
Which one? I have been served only one copy. Pranab Prasad Bharat.
Dipankar Chatola and Pranab Prasad Bharat same step, in both cases.
So you're not interested to, Mr. Moto, you're not filing a reply. I think we can proceed with the matter then.
That was served on 8/4, my lord. 8/4.
Pranab Prasad Bora 84. It is available.
And Dipankar Chatola also on 8/4, same day.
There is another petition.
Yes, sir. Satula also filed under 8/4.
Dipankar Satola,
Yes, sir. That is also filed.
84 filed.
On the day of the, my lord, very day of the last occasion, my lord.
Hmm.
I have to, my lord, go through, my lord, but so far the affidavit, my lord, is concerned, this is, my lord, I am not on that, my lord. But whatever they are getting, we are saying that I got, my lord, in the subsequent medical board, my lord, this disability was found in lesser than my certificate. I am on that, my lord, I am on that, the procedure they adopted to verify my medical, my lord, disability. Because that cannot be done without following the procedure of the law and rules laid down in the, my lord, disability, my lord. This was my case. Because once I have been certificate issued, this is when a competent authority was constituted by subsequently when another body, they cannot nullify my certificate. This is my case. They whimsically, they constituted a medical board in the medical college and I was directed to appear before the selection of this medical board. I was examined, they found some, and moreover, some of the candidates who are getting less medically paid in the subsequent board, they have been appointed, but I have been not appointed. This is my case. So I have to come with all the things, right?
So shall we take it up for final consideration today?
So then, but I'll talk sometime, so give the reply list. Because the issue is not that they are saying.
IAC 1015/2024. Heard Mr. D. Mohanto, learned counsel for the petition, for the applicant. Also heard Mr. P. Mohanto, learned counsel appearing for the petitioner, and Mr. A.R. Tabildar, learned standing counsel, Higher Education Department. The present application has been instituted.
Number 3.
Also, for respond number 3. 3. Okay. No. Respond number 3 is who?
Union of India.
Oh, CGC. No, one for CGC for respond number 3. CGC liko. Respond number 3 mat liko. Full stop. The present application has been instituted by the authorities of Koliabar College praying for a modification, vacation and or modification of the order dated 14/12/2022 passed by this court in WPC number 7992/2022. Full stop. The connected writ petition was instituted by several writ petitioners, including what is her name?
Sima Bhuya.
Dr. Sima Bhuya.
Huh?
Sima Bhuya.
Including Dr. Sima Bhuya as a respondent number, as writ petition number 3. inter alia raising a grievance with regard to the manner in which, in pursuance to their selection against the post of PWD as available in Kolyaba College and other colleges, their such appointment was not materialized on account of a subsequent re-verification of their physical disability done by the respondent authorities. So, this court, wide an order dated 14/12/2022 passed in the above noted writ petition was pleased to direct that the post of assistant professor in the departments of Assamese in Soigaon College, economics in CKB College, Assamese in Kolyaba College, Nagaon, and economics in CKB Commerce College, Jorat, under PWD category shall not be filled up. Right? Shall not be filled up.
Yes, that was the
Also, the respondent number, petition number 3 was a candidate for the post of Assamese in post of assistant professor in the Department of Assamese in Kolyaba College, Nagaon. So accordingly, the college authorities, in view of the said position, could not proceed with the filling up of the post in question. However, it has been pointed out it has been stated in the past that the petition number 3 had withdrawn from the proceedings, withdrawn her name from the proceedings of WPC number 7992/2022. Also, accordingly, the said interim direction as passed by this court-wide order dated 14/12/2022 cannot any further be applicable into the case of the writ petitioner number 3 upon her withdrawal from the proceedings of WPC number so-and-so, 7992/2022. In view of the above position, it is hereby declared that the interim directions as passed by this court wide order dated 14/12/2022 in the above noted writ petition shall not be applicable to the post of assistant professor in the Department of Assamese in Kolyaba College, Nagaon. Also, accordingly, the college authorities would be at liberty to proceed to fill up the said post in accordance with law. In accordance with law. With the above observations, the interlocutory application stands disposed of.
Obliged.
When do you want it, main writ petition?
After 1 week,
All ready after 1 week. List the main writ petition or as prayed for by the parties. List this matter again on Thursday, 16/5/2020.
Chief, we have forwarded it to the issuing authority for re-verification again.
Again, second time.
Second time for re-verification because they were the issue. Our name was not there.
Today there was a re-verification done and second of we'll pass orders, 40% was found.
If Lordship, the issuing authority again finds it to be
Proper.
above 40%, then we will consider. We have stated in our affidavit.
When did you send? When did you send?
23, but the issuing authority has not Lordship reverted back the result, Lordship.
Kindly
It's
see
the
whether
health department, they will have to Lordship.
we'll give you some more time.
The second list, in the second list, our name was not reflected.
Not there. Okay, 13/5.
Because I am challenging the entire procedure,
Okay.
whatever they have adopted.
Fine.
All right.
Simon? Yes, Mr. What is your?
My lord, from the list, my lord, the department has agreed for serial number 16, my lord, Vidyut Kumar Pradhan.
Okay, their only objection was with regard to 16.
Yes,
Vidyut Kumar Pradhan.
yes.
Okay, we'll.
But my lord, I was wondering about the procedure, my lord, under what procedure, because they have filed a review, my lord. The review is in fact not maintainable.
We'll say.
My lord, I'm relying on the judgment of our court. And my lord, so far as the agreement of the parties to change the arbitrator is concerned, my lord, I was going through the provisions, my lord. Section 15 of the Arbitration Act. My lord, that would come into play, my lord. Because my lord, now the arbitrator has already taken his charge. My lord. The arbitration proceedings was going on. Now at this stage, my lord, they have filed a review saying that they don't want this arbitrator without challenging the, my lord, before the arbitrator. Because
So you
as
want
per
us
the
only
procedure,
to-
my lord, under the Arbitration
Okay,
Act. it
if
has-
that is the objection, we'll hear the matter.
No, my lord, it can be.
We'll hear the matter. If
No,
there
it
is an
can be
objection, we'll hear
disposed
the
of, my
matter.
lord, only by submissions will be recorded.
Why should I record?
Hello.
If
Because-
you are agreeable to have that 16, serial number 16, we'll pass an order.
No, for
If
that-
you are not agreeable,
Yeah, agreeable-
then we'll have to
agreeable to
go
that,
for
my
a
lord.
dispute. Mr.
No.
Gupta, be clear, there is no problem with this court. If you say 16, both of you, we'll close the
I am
matter.
agreeing to that, my lord. Only the point
Then-
of the review is not maintainable, that may be,
That we are not
Because-
going in. As agreed to by parties, we are closing it.
in that case, my lord, will take section 15 for a moment, my lord. Section 15 of the Arbitration Act.
Section 15, arbitration. Tell me what you read.
My lord. My lord, section 13, my lord, deals with the challenge procedure. My lord, if any parties are agreed by the appointment of an arbitrator, my lord, the challenge has to be made before.
Mr. Council,
Well, I'm
there
just
was
pointing
there
out-
was a grievance raised that the council had given his consent without.
Well,
It's even if I have to go, I'm ready now. It
Well,
would be
under
a
what
review on
this-
procedure. It will be a review on procedure, not a review on merit. This would call for, because that process by which the consent is now being questioned, it was
But
said
now
that
they
the
are not
consent.
questioning, my lord. They are not challenging the list or the process.
No, they are saying
The
now
name
that
has to be changed.
15, what do you want here? 15.
Section 15, well, under what provisions it can be done at this stage, my lord? To that, my lord, effect, I am pointing out this provision. In addition to the circumstances referred to. under
Or
sec-
by or pursuant to agreement of the
Of the
parties,
parties.
15B.
Yes,
So under
yes.
15B, you can do it.
Yes, that is what I want to.
So we'll say that although the review was filed,
The
it
substitute-
was agreed between the parties that they are agreeable to the name of
My lord,
Mr. Vidyut Kumar Pradhan.
my lord.
And accordingly, this court directs that Vidyut Kumar Pradhan shall enter into reference
My lord.
and proceed with that matter in accordance with law.
Yes, and from that stage itself, when the
But that will not say,
Because-
wherever it is.
interest element involved, the proceedings are continuing, my lord. It will continue from that stage.
It is otherwise a proceeding for substitution
Yes,
earlier. Earlier was a proceeding for substitution. No,
no,
they have filed their claims in the matter.
yes, earlier it was for substitution, yes.
That's what I'm saying.
Yes,
The writ
yes.
petition was for
Section-
arbitration
substitution.
petition was for substitution. So from that stage, naturally it will begin. It can go back to the earlier thing. I'm here, I'm open to both. If you want me to have the second way also, I'm ready.
No, my lord. Under
This will
what
do.
provision can be done to that effect only I was
Okay.
pointing out.
Second of
15B.
Yes, Ms. Alam. You have filed your affidavit.
Yes, ma'am. This is for recognition of a beard college, my lord, press beard college.
This will have to be heard.
Yes.
Passed out. We'll have it on some other day.
Oh, shit, my lord, it's up to me.
Heard Mr. DJ Ghosh, Learned Counsel for the petitioner, and also Mr. Ilam, Learned Standing Counsel, NCP. Let's this matter again on 16/5/2024 for 5 hearing. 16/5.
That's my lord. This matter will be again remanded to the appellate authority. What I find is that, my lord, here.
There
subject to
has
what
to be.
lordship
We'll
said.
have to go into the provisions, the powers also.
Yes, yes,
I've gone through. We'll have to examine that as.
yes, yes, my.
Next.
My lords, the two aspects, my lords, this matter, well, I'll seek some more time, and my lords, the response of the member secretary, herein the respondent number 2, my lords, who, the member secretary has to respond, my lord, they have not responded till yet.
under the direction of this member secretary, my lord, this board, my lord, this SEBA is the conducting agency.
Two petitioners' grievances, there is no Hindi paper. It was not in Hindi.
Yes, ma'am.
Now they have clarified. By a corrigendum was issued,
Yes, ma'am.
Hindi was removed. So those two will have no grievance.
Yes, ma'am. That's a definition.
And with regard to the marking, how can this court come in? Who are we?
My lord.
Who are we?
My
We are
lord,
nothing.
so, my lord, I know there are there's a limitation.
Latest decisions of.
Yes, I have gone through, my lord.
Then?
But I have to, the onus is on the petitioner to demonstrate the palpably, something is on the face of record, something is wrong, which can remit the matter back to an expert body by the court. So, well, I need some time. I'm
No,
collecting
we have
those
given you
matters.
enough time.
Well,
This court
just-
has given you time on 2 days.
just 2 weeks.
Why should I?
Finally, my lord, 2 weeks, my lord. I just need some time, my lord.
No, no.
Because I have to bring
There is a,
on record
it's
some
not going to
materials,
take this matter anyway.
my lord.
Give it a quietus.
My lords, since the onus is on me, my lords, I have to bring on record some material which will show the very,
If you have not been able to bring it
it is on the,
from 23, after you filed the matter,
my lords.
how can you bring it today?
No, my lords, I'm on the verge of collecting, well, I'm collecting the textbooks, the source itself.
Collect it. Next round of appearance in
No,
exam.
my lord,
Use that.
that is too
Not
far for me. So, my lord, I'll seek just a word.
Or
2
in
weeks
appeal.
time. 2 weeks
We'll
time, a
dismiss.
fixed date, my lords. No further time, my lords. I've gone through all the judgments. The onus is on me. The court doesn't have the expertise, and the onus totally lies on me that I have to satisfy that something is wrong, which
There's nothing wrong.
there's certain aspect of it. My lords, just a 2 weeks time.
It's interpretive. It's what is your interpretation? An interpretation is not a mistake. They can have an interpretation. It's not a mistake.
Well, just a 2 weeks time. My lords. I have collected some materials, my lords.
On the prayer of Mr. D. Gogoi, as a last chance, list this matter again
My lords.
on 15/5/2024, enabling the council to bring on record materials to justify his stand with regard to the marks as claimed by him.
Lordship will keep it as part, my lords.
No,
15, otherwise.
29 to this two year going.
Lordship, in item number 29,
Oh,
Lordship, I'm appearing for the finance. Lordship, I'm seeking some time to file a affidavit, Lordship.
Hearing matter.
Lordship,
They have not filed, my lord.
even the education department has not filed, Lordship. That is like, if Lordship will grant it.
We don't require, we have already fixed it for hearing. Affidavits are not required anymore. You filed a miscase.
Lordship, one last chance, we just missed out, Lordship. Let us just,
That I can accommodate.
yes, Lordship.
That I can accommodate.
One.
A date will be given, my lord.
Mr. H. Aliya Learned Standing Council, Finance Department submits that the matter was missed out by him, and accordingly he could not bring on record the requisite affidavit on behalf of the respondent authorities. So, sir, prayer accepted. List this matter again on 20/5/2024. So, sir, for hearing. The respondents are at liberty to bring on record their pleading if so advised on or before 16/5/2024. Rest matters will come back and
8,000 to so and so. Promotion to be filled up by promotion except when its opinion of the appointing authority, suitable departmental candidate are not available. Essential degree of a recognized is about 4 to 5 years experience of tea culture and manufacture in all its experience. A diploma, degree in agriculture, education and qualification may be relaxed in the case of other experience suitable by selection from development officer.
so basically a degree
Basically,
and a 4-5 experience in tea culture and manufacture, right?
yes.
The desirable will not come, and there is a requirement for any relaxation in your case. You have a
No,
degree.
not necessary. So
So then what happened?
then, my lord, our submission is that at page 6 of para 8 of our writ petition.
No, show me the order by which.
Order by which this is the order we have been promoted at promotion order is at page my lord, page 23. Sorry.
Mhm.
Page 27,
27,
2021.
18/7/2011.
2011, petitioner number 1 was promoted. Petition number 2 and 3 was promoted. Serial number
Rituraj
5
Hazarika and
and
Sanjeev,
Sanjeev Rajbangshi, 2 and 3.
petitioner 2 and petitioner
Three.
3. Then
My lord, they are promoted against their against their vacation.
then
My
what
lord,
about the other two, other
page
petitioner?
29, page 29 is other one, petitioner 1.
Page 29. Nipun Borman.
Yes, the undersigned is directed to say that Sri Nipun Borman, development officer attached to the T-Boards officer, Connor, working in the revised pay scale of so-and-so, is hereby promoted to the post of officiating assistant director of the T development in the revised pay structure, so-and-so, grade pay plus usual allowance with posting of officer, sir. Now they have issued a print order at page 30. Office memorandum number 139, this is dated 1st of July 2013. Promotion was on 9th of August and July of 2011. After about 2 years, the imprint order has been issued. Whereas the central government sanctioned additional post of assistant director T development as per the T board and promotion rules 1971. These posts are to be filled up by promotion except when the opposition of the appointing authority suitable departmental candidates are not available. The mode of promotion as per the existing RR has to be through selection against assistant superintendent development, redesignated development officers. And whereas selection has been defined in the existing RR to mean an employee's performance on oral or written test as prescribed from time to time. And whereas it has been brought to the notice of the competent authority about guidelines issued by the DOPT OIM dated 8/2/2012 and OIM dated 16/2005, wherein all the ministries are subordinate organizations, there had been directed to amend the recruitment and service rule in incorporated method of selection and effective promotion. And whereas in the DOPT circular number so-and-so dated 24/3/2009 and 12/3/2010, the minimum qualifying service of the promotion from the post of having the grade pay of 4200 present so-and-so, grade so-and-so, having grade pay of 500 development has been kept in 8 years. So they followed the promotion recruitment rule qualification 4 years residency period in the feeder cadre. Now they have increasing in terms of the DOPT OIM, they are saying that since we have not qualified 8-year service to hold the post having grade pay of 5400. And whereas no existing development officer neither have 8 years of so qualifying have been minimum qualifying service period 7 years as per 1971 RNP rules present being followed in the board. And whereas the Nipun Borman so-and-so, assistant director T development is their promotion date given 18/7/2011, 9/3/2011.
You're continuing as there is an interim director. You're continuing.
By virtue of the interim order, we
You're
are
continuing.
now after examining, it has been found that the promotion of Sri Nipun
That
Borman
they
is
cancelled it.
cancelled.
Then there was page 32 and moved to have it by direct recruitment.
Yes,
Okay.
they have not in their affidavit also, they have not denied the recruitment role.
Now you come to page 35. They say 2 years
Yes.
residency is required.
Residency. Another, my lord, form they have.
Mr. Day, we have passed the orders. You will have it in a day or two. Okay, just pass the orders. Anything more to add to that?
Saying that the vacancies are still there.
You have any instruction to that effect? Okay, we'll add a line that you are given a liberty to make an application. And if there are vacancies as of that date, because of the pendency of the present proceedings, they will consider your case. Will that do? Okay.
Most grateful.
Okay, 35. They say that 100% promotional post 2 years.
Yes.
Okay, then what happened?
Then, my lord, after receipt of we have approved this honorable.
And
The
that was state.
challenging that interim order granted.
Okay, what happened in Calcutta High Court?
Calcutta High Court, my lord, Calcutta High Court in no way because they did not, they only 2 years. They put to service only 2 years and Calcutta High Court said the affidavit at page.
Come to the order at page 50.
Page 50.
50, the order of the single bench of the Calcutta High Court. In my affidavit also. The proprietary post one is 50.
Calcutta High Court, my lord, they relied on a office memorandum of June 18, 2013. Employees of the page 50, 12 employees of the T-board challenges a notification of June 18, 2013 being arbitrary and discovered in the petitioner's right and legitimate expense of promotion post being denied thereby. Petitioner
You
also
were promoted in 2009.
11.
11.
Okay. July and August. They have, my lord, they have tasked, contended before the Calcutta High Court with regard to our promotion also. And Calcutta High Court has said the petitions are pending there in Guwahati High Court. They have, observation has been made, but no discussion is there with regard to the recruitment rule provision. Calcutta had drilled only on the basis of the office memorandum. There is no analysis of the recruitment rule, and our contention is that you cannot take a
In the
right.
appellate court, also same.
Appellate order is lordship, it starts at page 57.
I know that, I'm seeing it.
The 50th next, the retired post of filling of the vacancies in the post of assistant director of tea development in the is development officer by promotion. The minimum qualifying service for promotion from the post having the gates pay for rupees 4,200 and so and so was declared as 8 years by DOPT circular number AB 14017 of 2008 establishment dated 24 March 2009 notice and 12 March 2010 notice. As per DOPT, 8 years is required notice for promotion to the post of assistant director of tea development.
Now tell me one thing, Mr. Mitchell. You have a rule, service rule. Without amending that, how can you, how do have you framed this rule? What is the basis of this rule? Where is the, this is the rule at page 11. This bylaws may be called, this is the bylaw.
Bylaw. Okay.
It is under that.
Under that.
That's it.
And this is approved by the central government.
Central government.
Without amending this, how can you, there may be many, but you have adopted this.
That's it.
How can you go beyond this?
So in the time, at the time of motion, I think Mr. We admitted it in the affidavit also, but as per DOPT,
DOPT, you amended, then you go.
it is not done.
Then
Subsequently, they have amended
Subsequently, it amended in
2015.
2015 amended.
15.
To the effect of?
With effect from the here, my lord, I have the copy.
With effect from lordship,
No, no, no. To the effect, what was the amendment made?
My lord, this amendment is notified, notification dated 22nd November 2015.
2015.
These bylaws may be called T-Board Recruitment and Condition Service Rules of the 2015.
That's it.
And the amendment is to the effect?
To the effect, my lord, the condition is that they contended the condition, earlier it was 4 years service, now it is 5 years service.
Not 5 years.
5 years.
5 years. By this time, we have 2015. That is, my lord, another aspect is that the rule there is not retrospective effect, not retrospective effect. We are promoted under the rule, earlier rule.
Huh.
That is retrospective.
So once you don't amend it, how can you bring in office instructions, memorandum? You cannot.
Yes.
This is the issue. What is there? Where is the interim order?
Interim order. So in 2013, lordship.
My lord, I am relying on the my lord court judgment.
Yes, yes, just a moment. Let me have just. So 3 posts were kept in vacancy. Impugn order kept in abeyance. Yes, which is the judgment?
Judgment, my lord. My lord, now by virtue of the interim order, during this period, we have served more than 13 years. About 13 years, more than 12 years. So, my lord, I am first of all, I am relying on the judgment of the 1979 1 SCC, page 160, Ramswarup. Ramswarup, para, my lord, page 170, para 3.
The question that arises,
No, I got it. Once you get it, you are regularized.
Yes.
Then next.
That- next, my lord, I am relying 2005 8 SCC 394. This is a para relying para 26 and 28. That is rule framed under 309 proviso or cannot be
This is not a 309.
9 proviso.
but
It is under
is
bylaw.
akin.
Bylaw under the act.
So this is also not applicable. Then next.
My lord, then another my lord in Punjab State Warehouse,
Hmm.
2007 9 SCC para 11 relevant. The terms and condition of employees of the appellant corporation, it is a corporation, being governed by a statute and statutory rules, would have been altered only by reasons of amendment of these rules only. The state, as is well known, has no.
Is
say-
there any finding in the Calcutta High Court judgment that the rules that are governing the field are not mandatory, are not statutory, or
No.
are not binding?
No, that
Nothing.
line there is nothing. That discussion and no argument was also put forward there.
So basically, why should we go into all this? We can only say that once there is a bylaw,
Right.
one line I found somewhere. Wait just a moment. Where is that Calcutta High Court judgment?
Calcutta High Court judgment. Calcutta High Court judgment was made. Appeal order is in place.
There is some reference to in absence of any bylaw. Yeah. Come to page 66.
The division bench,
Ah.
division bench.
So
The absence of any bylaws framed under.
where is the
section
bylaw you just showed me?
Say that the T board in our considered be the competent to take decision in its administrative side for regulating the service condition of the
See,
employee. And
But
application
this is a bylaw framed under section 50.
50. That is that bylaws, my
So
lord. I am showing.
that observation, that's why I was.
That I am showing. My lord. This is
Yes,
a,
page 11 of your affidavit. So this is perverse, this observation.
this observation. I am showing, my lord. This is.
Yes, what are you showing?
Page 23 of our merit petition. That notification of 25th May of 1971, notification T control GSR so whereas a draft of the T board's recruitment and commission officers appointed by government rules. Yes, published required under subsection 1 of the section 49 of the T Act. This is under the Act, my lord. 29 of the pages of so Gazette India, part 2, section 3, subsection.
You are reading page
Page 23.
20?
3 of my writ petition. Notification of government India in the foreign traders and distributed.
There's something, oh, wait. The petition. But this has been repealed by that 2011, 9. 2015.
That is 2015. And when we are promoted, these are holding period. This is under the Act notification. And the 7th.
Okay, central government has made these rules.
Yes.
And herein, the requirement is,
Requirement is 4 years.
this was then amended
These are that subsequently 2015.
15.
2015 amendment is in my hand, my lord.
So this rules, where is section 50 of the T Act? You have the T Act with you?
T Act I have put my lord, I forgot to bring it.
Okay. Because then that observation of
Division
Calcutta High
line.
Court has to be looked at.
Here it is my by access under section section
49.
49 of the TR. Page 23.
Yeah, doesn't he, Amar? You have.
এখন আছে না, টি এখন আছে। Well, I am coming to page 26 of their affidavit, 1981 bylaws. That is under section 50.
Where is that page?
That's page 26 of the affidavit. This has not been dealt, they are in the division bench judgment, in their affidavit. New Delhi, that is the Department of Commerce, Ministry of Commerce. These bylaws may be called page 26, 26.
Ujjwal Kanti Pandit.
Yes. Affidavit filed by Ujjwal Kanti Pandit.
Ujjwal Kanti Pandit.
It's something.
That is. This too.
Hmm.
Page 19 and 20. 19 and 20.
19 and 20.
20, not 26.
Annex one also.
तुम्हारे page presentation का 20. That this new, this is the bylaws framed under section 50. The following bylaws further be amended T-Board bylaws 1950 made by the T-Board in exercise of the powers conferred under subsection 1 of the section 50 of the T-Act 1953 are hereby published for the general information. The same have been confirmed by the central government. As required by the subsection 2 of the section, namely, the bylaws may be called the Board of Amended Bylaws 1981. They shall come into Gazette force date of their publication of the official Gazette. Now, my lord, they have relied on this, the creation of the appointment of the post, and they enclose page 23, 23, 24, 26 is the promotional.
Where is that in the body? That 23 onwards.
That is their affidavit, my lord.
Because 49 does not deal with employees.
Section 50 for the bylaws power given to the board.
(50E)(1)(E) mandates that board can make bylaws for the condition of service of its officers and other employees. Huh?
Yes.
And only requirement is under 52 for a confirmation by the central government. Okay. Now, come to this last one. No, this 82 is nothing. 81 is nothing. 81 is nothing. Right? 81 is nothing. Because if you come to your that 2015 amendment, it amends 71.
71.
So
So they by the,
71 is not under 40, 50.
not under 50.
It's 49 is it's a wrong.
Wrong.
Then
Wrong application of the. Only 50 they can apply and under 50, they what the bylaw they have framed, that bylaw also 4 years condition is there. They are affidavit.
take me back to that 71.
81 bylaws under the section 50.
No, 71.
71 is at page. I did PC can is 26. 23 in the this is some actually. Page 23.
This has been annexed by you in your writ petition.
This I have annexed. They have not denied this contention. In affidavit, they have all along said that as per the rule, it is 4 years.
Mr. Counsel, Mr. Chaudhary, I think there is an error here. Typographical error. Where is the original of this?
This is the. I have the original.
It cannot be 49.
Cannot be 49. That I have also mailed that.
This is also typed.
This is the original. 49 likha hai.
49.
49. 40. Even the.
No, it is wrong. Because 49 does not have 1D.
Exactly.
50 has 1D and 2. How can you get this redressed?
It is typography. It cannot.
There may be a subsequent clarification given. Because if you come to the opening paragraph, power is exercised under 1, 2, 3, 4th paragraph. Now, therefore, in exercise of powers conferred by subsection 1, read with clause D of subsection 2 of section 49. Okay. Okay. 2D. That is power and other conditions of service of secretary and other officers appointed by the central government. You are not appointed by the central government.
No.
You are an employee of the T-board.
By board. By T-board.
Then it will be 50 only.
50, then
So
my
these
lord,
rules,
that the 50, at their affidavit, they have enforced page 20 under 50 by exercise power under 50 bylaws.
bylaws, but that bylaws have not defined the services. Because in the body, you don't find anything.
Yes, that body, but the rule they have the.
So that under 50, it is not there. The observation by Calcutta High Court
Yes,
is correct.
50, they have Calcutta, that, but this bylaw has not been dealt by the Calcutta High Court. They are relying on that bylaw in their affidavit, 81 bylaw.
Mr. Chaudhary,
81
we have the latest setup
Amendment.
of the T Act here with us.
bylaw.
Why don't you go back and examine as to whether this section 49 is the present day section 50? Subsection 1. D. Okay. 49 and 50, there is a difference. 50, power of the central government to make bylaws.
Yes.
And 49, power of the central
Central
government to make bylaws. And 50,
Power of the
power
board.
of the board.
But approval required to be a government.
Then so 2 approval will be taken.
Required.
But here, 50 will only be in respect of, 49 will be only in respect of persons who have been appointed by the central government.
Central government.
Come to section 9 of the Tea Act. Interesting. Now the matter is getting interesting. Section 9. Mr. Chaudhary, examine the Act, T-Board Act, Tea Act. Examine section 9(2). I think it's an inclusive decision. So this will cover all. Yes, what do you say? What is the rule you are holding? Okay, what is the rule under which they were promoted? Right from, what were the rule you utilized?
In 1971 rule.
1971 rules. Or we'll have to go by the principle that, okay, on that day they were not there. But now that 5 years thing having been prescribed, so the day they completed 5 years from that day, they will be held to have been promoted. Other part would be adopt. Yes, Mr. Chaudhary.
May not. Yes, not. Sorry.
No, sorry, not. What do you say?
My lord, my humble submission is that 1971 rule.
There is an ambiguity.
There is an error. But they have recent amendment of 2015.
That they have done it.
They have done 1971.
But they have taken away the effect of
And
71 by this.
all along, they have contended in their affidavit that we have been promoted under the 1971 rule. Only thing is that we did not fulfill the DOPT instruction criteria for 8 years service. That is their contention in affidavit.
And you have said 8 years. But when you made the amendment, you made it 5 years. Why?
As per DOPT, it is 8 years. As per the
But if you are following DOPT to remove them or to cancel their appointments, so 4 years down the lane, when the rules were amended or the new rules came into being, why have you incorporated 5, not 8? Right? Not right?
Yes. So affidavit was filed in the year 2019.
15.
Okay.
Okay. What is the next promotional avenue available to you?
Next promotional avenue in terms of the reality director. System secretary.
You are assistant director,
Assistant Director.
next below post
Next
of the
below.
director.
Right.
It says assistant director Hindi. Okay. So now give me a small note.
Well.
Hmm?
Well.
When? Day after?
After.
We'll not go into all this we'll note all this. We'll not go into the controversy. We'll say they have continued for such a long time. And even if it is 8 years, you have subsequently in 2015 said 3 years later, without there being change in the DOPT being brought on record, you have put it 5 years. So, subject to what we finally decide, either that we will uphold the promotion or we will say that 5 years onwards, they'll continue. And that 1 year, whatever it is there, that would be adopted. And their benefits for further promotion and all will be considered on completion of 5 years. Hmm. But why this 49 has been used? 49, check up
Yes, my lord.
that act as it was on
I
that.
have checked that. 49 is not for this.
No.
Not for,
49, the provisions are also wrong.
not for say.
Subsection 1, 2D. 2D is central government. So how can you apply 71 to your employees? You can't. That is why the Calcutta High Court is correct. There is no other contender,
No,
no contender
no, my lord.
claiming your post.
No.
Let them continue.
That is why, my
Not
lord, we are,
causing prejudice to anybody.
that is why, my lord, we are enjoining the promotion by virtue of the stay order since last 10 years, more than 10 years.
Last 11 years.
11 years.
Okay. Heard the parties at length. List this matter again on 29/4/2024. You give me that note on
Alright.
Thursday
Definitely.
for delivery of this.
My lord, note to be given day after tomorrow,
Day after tomorrow, Friday, whenever it's possible.
mentioning I will
Mention time you can just.
again. Alright.
Lucky to work later. I'll to work through delivery. Yes,
I have already informed the council, finance department. He is in red, in court number 1.
it is stated that the standing council finance appearing in the matter is on legs in a different court. Accordingly, list this matter again on 6/5/2024. 6/5.
Excellent.
Any problem? You give me a date. I'll accommodate. When?
In the next day.
Next week.
Yeah.
Okay. On 13/5. Will do? Hmm. Table of the chargeable. আৰু কিমান আছে? দি লওকচোন, বাকী কিবা দি লওক। 5 minutes, I'll just finish up the list. দুটা order আছে তো, কিটা নালাগে, বাকি order নহয় কিটা। Yes, Mr. Barbujit.
I beg apology, my lord, so far as item number 10 is concerned, my lord, I was here, otherwise lordship has fixed it on 13/5.
If you are here, we can do it.
You can do it on 13th of May also, because issue is on a very narrow campus.
That's what I said. Why go to 13/5? Again, carry this file. Argue today.
today.
Argue today. You ready? Are you ready?
There was a selection process.
Yeah, 10 to due. Yes, sir. What's your case?
I am challenging the order dated annexure 14 and 15. Page 34.
There is a private respondent, but he is not material.
No, my lord, if I may put it in a nutshell,
There was a selection process.
selection process for.
He was appointed. Somebody else came up before this court, made a challenge. He was not made a party. The court said that his appointment is not proper. It has to be given to the other person.
Otherwise,
But this court, because he was not before this court directed that if any steps is taken, it would be taken after giving him due notice.
minimum opportunity of hearing.
Hearing.
That is.
So you proceeded with the minimum opportunity of hearing. He approaches this court.
That's it.
This court thereafter stayed the order.
Yes.
Now, what is the position in the field? Both are working.
Yes.
Continue with that. Why disturb after 10 years?
Now, to that extent, my lord, whether the petitioner is working or not, my lord, I. have
Petition
made-
is working.
Working also.
Working.
Since 27/11/2014.
I may have to say this.
So there is a,
And there is a last gradation list.
Because, my lord, it was
2023.
last listed, this matter was last listed in the year 2015. Thereafter only it has come today. But I need to also reconstruct the file also, my lord. I have just gone for the case record.
you get your instructions then.
Therefore, only to the limited extent.
Only to
So
that
lordship can fix it on 13.5. In the meantime, I will. get
No,
that-
when are you going out? For elections? List this matter again on 29/4, Boydu.
My lord, can it be in the
30.
first week of May, my lord, any date, my lord, 2nd of May, my lord. 2nd or 3rd of May.
When are you going?
Okay, I will come back again.
No, when are you going? No.
25.
And you are coming back?
Before 30, I will come.
30th. We'll have it on 2nd. Any inconvenience?
No.
2nd. List this, on the prayer of the parties, list this matter again on 2/5. If they are continuing, there is no point.
Both
Because
respondents
that
were-
There is a statement.
That order is not put to challenge. It has
Sure.
attained finality. The earlier order of the honorable. Court.
And there is a gradation list, both are already.
This court never said that he should be terminated because something was erroneous in his case. This court's observations are to the extent that in terms of marks, if the other person comes in, then he'll have to make way.
Yeah.
Now, without making way, if he can be accommodated and the other person is also accommodated,
Yes.
what more is left?
I will be seeking a copy of the writ petition from my learned colleague. Yes,
Okay, I will provide it.
Give him.
Okay, I will provide it.
I am so obliged.
Much obliged.
Mr. Soikia,
My lord.
2011 or 2017? One word.
My lord,
Choice is yours.
actually, my lord, they should have get the benefit.
2011. Okay. On the prayer of
My
Mr.
lord,
K. Gogoi. Mr. Gogoi had made a request that if it is 2017, he has no objection.
my lord.
And if 2011, then he said that this could be hearing, he is having some personal difficulty. On the prayer of Mr. K. Gogoi, learned counsel for the petitioner,
At
list
least
this
say
matter again.
Dispose of the matter, my lord, by 2017.
Nothing like it.
Because 11 Act is no longer there, my lord. But they should have given the benefit under 11.
Have you approached the authorities under 2017? No.
Approach, my lord.
Where?
Approach, my lord. Representation lawsuit file at page.
I am holding
51.
627.
51, my lord.
Huh?
51, page 51, my lord.
51.
51. After, my lord, 2017.
This is 1/1/2013. Under the 11 Act, 51.
My lord, 51 is 8 to
21.
That you are claiming from 1/1/2013 means under the 11 Act.
Yes, my lord, but
No, no, if you have a case, if you can make out a case for 2011, I'm ready to hear you. Only thing this court will require is 10-4 you have crossed. That means there was creation of posts
yes,
and a notification was issued. Just show that much, I'll take the order. If that is not there,
but my lord, perhaps my lord post was not created
then
because my lord,
Then-
what happened, my lord, the
see, there is a decision of this court also, that is mandatory.
district security committee, my lord, recommended my name
Hmm.
for provincialization.
Then
But the
director,
state level committee, my lord, they published me to be underqualified.
director.
Yes, my lord.
There was no state level, the director.
Director,
Director held you to be underqualified.
underqualified.
And the matter remains such. Others got
My
provincialized.
lord,
Now afterwards, the act gone.
my lord.
So within the declaration of underqualified and the act going, no steps were taken.
No steps.
So after that, you have nothing.
But
So the only way out is 2017.
17 act, under 17 act, they can provincialize my service.
We'll direct you to submit a representation. We'll hold that you have a right under the 2017 Act to be considered, if not as teacher, as a tutor. Submit an application before the
They're
director.
librarians, ma'am.
Huh?
They're librarian, my lord.
Librarian.
All the three petitioners.
All the three are librarians. You will approach the
Director.
director, higher education. He will examine. If he finds that you fulfill, he'll place your case before the district director, district level scrutiny. From there, 3 months, final order.
It is held by, my lord, it is held by your lordship, my lord, that he is entitled to be provincialized under 11.
We will not do that. We will not do that. We will not do that because that is not beyond, that is not within me. That examination has to be done by the authorities. Once they do it, come back, we will interfere. But initially, we will neither say you are ineligible, nor say that you are eligible. We'll only say that you have a vested right to be considered.
Fine.
Right?
Fine.
This is item number.
16, 17, 18, my lord.
This was the head.
Oblige, my lord.
Oblige, my lord.
Heard Mr. K. N. Chaudhary, Leonard, Senior Counsel, assisted by Mr. S. Das. S. Das.
Yes, lordships.
S. Das, Leonard Counsel for the petition. Also heard Mr. H. Gupta, Leonard Counsel, CGC, appearing for the respondents. Also, the review petitioners by way of instituting the present petition has prayed for a recall of the order dated 1/8/2022 passed by this court in arbitration petition number 2/2024, requiring the order dated 1/8/22 in arbitration petition number 2/2021. Full stop. This court, while the order dated 1/8/2022, basing on the consensus as arrived at in the matter by and between the parties, had disposed of the same, requiring the respondent authorities to proceed immediately for appointment of a substitute arbitration from amongst the MOD panel of arbitration, bracketed EOA, within a period of 3 weeks from today. Thereafter, the arbitration proceedings was directed to be commenced before the newly appointed arbitrator as mentioned herein. Thereafter, it is seen that the petitioners, the respondents had appointed. Where is that order? You had appointed somebody.
No.
Also. Thereafter, in terms of the orders passed by this court in arbitration petition number 2/2021, the respondent authorities had appointed an arbitrator on 16/8/2022. Right?
Yes, my lord. Yes.
Who was he?
Shri Ramesh Chandra, my lord.
Had appointed Sri Ramesh Chandra as the arbitrator on 16/8/2022. Full stop. Although the present proceeding has been instituted praying for recall of the order dated A1/8/2022 passed by this court in arbitration petition number 2 of 2021, it is seen that there was a consensus arrived at between the parties for an appointment of a substitute arbitrator from the MOD, Ministry of Defense Panel of Arbitration, bracketed POA, as available in the matter. Only the dispute was with regard to the person so identified by the respondent authorities. Full stop. During the course of consideration of the present review petition, the parties have arrived at a consensus with regard to the name of
Number 16.
Sri Vidyut Kumar Pradhan. No objection?
No
No objection. Vidyut Kumar Pradhan, who was a chief engineer, who had retired as a chief engineer mechanical engineering, bracketed DRM, from the Indian Railways. Also, and his name figures in the panel of arbitrators as constituted by the Ministry of Defense by the communication dated 7/2/2022. Also, in view of the consensus as arrived at by the parties in the matter and the party and the agreement with regard to have the said or have with Sri Vidyut Kumar Pradhan as the arbitrator in the dispute as involved in the present proceedings, this court would not further examine as to the issues arising in the review petition and would, on the basis of the consensus as arrived at by and between the parties, close the present review petitioner, requiring the respondents' authorities to appoint said Vidyut
Kumar Pradhan, my lord.
Vidyut Kumar Pradhan as the arbitrator in the matter within a period of 2 weeks from today. So thereafter, the arbitrator shall enter into the reference, and the proceedings, arbitration proceedings, shall commence before the newly appointed arbitrator. From this stage, the same was kept pending after the earlier arbitrator had withdrawn from his present proceedings. Also, with the above observations, the review petition stands disposed of.
Deeply appeal.
But you deprived this court from a knowledge enhancing exercise.
I had prepared it actually, my lord,
But I'll keep those judgments with me. I'm really into it now.
my lord.
Whenever I get time. Now I'm not on the judgments. I have started to find out certain papers from net.
My lord.
Are really interesting. The way they have examined the issues, and then you get the references also, but
Yes.
really.
Oh.
Delhi High Court, small, it's not a very senior person, he's a young guy.
Oh.
Forgot his name. I think there were 2 of them. Such a beautiful article they have written.
Oh.
I don't know where it is published. I got it randomly.
Oh.
Really. This is a live issue now.
Yes. Yes.
And the question Mr. Chaudhary raised that day, designate and quote change
My lord.
after the amendment.
Just say.
It's something, maybe in a given case, we will examine. Let's see.
It remains a judicial order, my lord. The order passed in the.
It remains a judicial order. But the only thing is, if I'm a court, then I have that inherent power of review, at least procedural review. Merit may not be. Procedural review, I have it.
Okay.
But if I'm a designate or the Chief Justice named, then that power has to be conferred. Otherwise, it will not come. That's what I've understood. Let's see.
One more thing, just I would like to add.
Yes,
sir.
yes.
11/7, my lord, the letter patents appeal is also part, it says that no letter patent appeal can be filed.
Letter.
Therefore, my lord, the order pass cannot be challenged before the same judge.
Court.
Same court, my lord. Only remedy is under 136. So in view of the fact that, my lord, there is
No, otherwise also,
provision for
you
appeal.
can, I think, make a challenge in a writ petition. Can it be challenged in a writ petition?
If the appointment is made by the district judge, my lord,
Then I can,
then under 227, my lord, there is one
I
judgment
can come here.
which I have, it can be challenged under 227.
Ah.
But if it is an order passed by the High Court, my lord, under 11.6,
Then no writ.
then there is no remedy. It has to be under 136.
36.
My lord,
Thank you.
Deeply obliged, Lord.
obliged.
This is learning process for me on these issues.
Obliged.
WPC 2144/2021. Heard Mr. DJ Ghosh, learned counsel for the petitioner. Also heard Mr. U Sharma, learned standing counsel. Mr. A Fukan, learned standing counsel, Education Elementary Department, appearing for the respond numbers 1, 2, 3. 1, 2, and 3. Also heard Ms. D. Das Burman. We have recorded your name, Mr. Fukan. Mr. D. Das Burman for the respond number, additional senior government advocate for the respond number 4. Heard Mr. J. Abedin, learned counsel, appearing for the respond number 6. The grievance as raised by the petitioner in the present proceedings is to the deprivation as meted out is the grievance as raised by the petitioner in the present proceedings pertains to the denial to him of the benefits of provincialization of his services under the provisions of the Act of 2017 and with regard to the extension of such benefit to the respondent number 6 herein, who has been contended by the petitioner to be not eligible for such benefit. Also, the petitioner herein was appointed as an assistant teacher on 5/4 by assistant teacher by the managing committee of Hondara Girls ME Madrasa on 5/4/2005. Also, the petitioner accordingly joined his services on 7/4/2005. Also, the school at the relevant point of time was in its venture stage. Also, the respondent number 6 hearing as projected in the respondent number 6 hearing was appointed as a language teacher in Arabic subject
6/9/2000.
6/9
2004.
6/9/2004 in the same school. Also, a perusal of the materials brought on record would reveal that the petitioner has contended that he, after his initial appointment in the said school, has been teaching the subject of social science in the school, whereas the respondent number 6 hearing was teaching the Arabic subject. The petitioner has contended that the respondent number 6, being an Arabic teacher, has to be construed to be a language teacher, whereas he, being a social assistant teacher, social science, and he as the social science teacher. Also, with the enactment, upon the enactment of the Act of 2017, the names of the serving eligible teachers of the school in question were taken up for consideration for provincialization of their services by the jurisdictional by the authorities, and accordingly the headmaster of the school had submitted the requisite particulars of all the teachers, including their educational and professional qualification. Also, in the particulars as submitted on 30/5/2017 by the headmaster of the said school, the petitioner was shown to have joined his services on 7/4/2005 and was shown to be teaching the subject of social studies, whereas the respondent number 6 was shown to have been appointed on 6/9/2004 and was shown to be teaching the subject of Arabic. Also, thereafter, the cases of the petitioner as well as the other serving teachers in the said school were considered by the by the district level scrutiny committee, and thereafter the names were so placed before the director of secondary education Assam by the district elementary education officer Bongaigaon. It is to be noted that the district elementary education officer Bongaigaon, while his communication dated 19/10/2020 had forwarded the names of the serving eligible serving teachers of the school in question, and therein had noted that the petitioner to be teaching the social science teacher subject, and that he had joined his services in the school on 7/4/2005, while the respondent number 6 herein to be teaching the Arabic subject and to have joined the said school on 6/9/2004. Also, it is the contention of the petitioner that although his name was so recommended by the district level scrutiny committee, his case was not favorably considered thereafter by the authorities, and on conclusion of the process of scrutiny, the name of the petition of the respondent number 6 was recommended, and accordingly her services came to be provincialized by issuance of an order dated 5/2/2021 as a tutor. 5/2/2021 with effect from 1/1/2021 as a tutor. Full stop. Being aggrieved, the petitioner has instituted the present proceedings. Mr. B.J. Ghosh, by reiterating the contentions as made in the writ petition and as noticed herein above, has submitted that the provisions of the Act of 2017 mandate the appointment of engagement of one teacher as a social science teacher in the school, in a ME school, and the petitioner having been teaching the subject of social science and the said position having not been disputed by the authorities and or by the respondent number 6, he should have been extended with he should have been accordingly his services ought to have been provincialized against the post of social science teacher in the said school. It is the contention of Mr. Ghosh that the petitioner hearing at best, respondent number 6 hearing at best can be construed to be a language subject teacher, and accordingly she there being a teacher senior to the respondent number 6 teaching the language subject in the school, the petitioner, respondent number 6, could not have been considered for such engagement, for provincialization of our services. So it is the contention of the petitioner that in effect, the respondent authorities have provincialized 2 language subject teachers in the school, along with 1 teacher teaching the science subject, and therefore has caused prejudice to the service interest of the petitioner hearing, who was entitled to have his services provincialized as a social science teacher in the said school. Accordingly, it is prayed that this court would interfere with the provincialization as affected in the case of the private respondent number 6 hearing, with further direction to the respondent authorities to provincialize the services of the petitioner. Full stop. Mr. A. Fukan, learned counsel, appearing for the Standing Council, Elementary Education Department, by referring to the affidavit as filed by the respondent number 2 in the matter, has contended that referring to an affidavit filed by the Director of Secondary Education, Director of Elementary Education, the matter has contended that although the District Scrutiny Committee had recommended the name of both the petitioner as well as the respondent number 6 hearing, along with 2 others, it was on scrutiny found that the date of appointment of the petitioner in the said recommendation was shown as 7/4/2015 packet of apostrophe. Accordingly, the date of appointment so mentioned in the recommendation of the DSC being contrary to the provisions of section 4 bracketed 2 bracketed Roman small 3 of the Act of 2017, it was held that the petitioner did not fulfill the requisite eligibility criteria for being considered for provincialization of his services, and accordingly, his case was not processed further for such provincialization. Right? Also, the Learned Counsel, Mr. Jainal Abedin, appearing for the Learned Counsel for the respondent number 6, Mr. J. Abedin, has submitted at the outset that there can be no comparison between the services rendered by the petitioner as well as by the respondent number 6 hearing, inasmuch as while the petitioner is a language teacher in the school, while the respondent number 6 is a language teacher in the school, the petitioner is a teacher teaching the social science subject. Also, Mr. J. Abedin has also, by referring to the affidavit filed by the respondent number 6, pointed out fairly that the petitioner was appointed on 5/4/2005 and had joined his services on 7/4/2005. Mr. Abedin, in his usual flair, has also raised an argument to the effect that the said school is a girls' school, girls' madrasa, and accordingly, it is mandated that there should be a girls' teacher, a female teacher available in the school, and it was contended that it is only the respondent number 6 who is a female teacher available in the school, and accordingly, the provincialization of her services being so done in the interest of the students of the school who are girls, cannot be questioned by the petitioner hearing, and the wisdom of cannot be questioned, cannot be permitted, should not be permitted to be questioned by the petitioner hearing. Also, Mr. Abedin, by referring to the recommendations of the district level scrutiny committee, where is that?
Page 53 is the
I've got it.
names of the teacher.
By referring to the recommendations made by the report of the district scrutiny, by referring to the report of the district scrutiny committee available on record, has submitted that the petitioner school, petitioner school was on provincialization, merged with the base school. What is the name of the base school? 482 number Bhandara Adarsha KNLPS, which was already a provincialized school, right?
Yes.
Also, it was pointed out that in the base school there was an enrollment status of students, but there were 252 students enrolled, whereas in the school, petitioner school, there were around 81, and on such merger, upon amalgamation of the petitioner school, the total number of enrollment, total strength of enrollment would stand raised to 333. Accordingly, it is contended by Mr. Abedin that considering the strength of students now enrolled in the school in question after amalgamation and the merger, comma, and the consequent merger, comma, there is a need for further teachers in the said school to meet the PTR ratio. So, however, the respondent authorities, without considering the said matter, had limited the provincialization as affected in the petitioner school to three posts by considering the provisions of section 3 bracketed 11 of the bracketed Roman 11 of the said Act of 2017, and it was further contended that the proviso as available, proviso to the provisions of section 3:11 was not given its due consideration. Also,
Is 3-1.
huh?
3-1-11.
3-1-11, sorry, 3-1-11. Also, nobody is appearing for the respondent number 5. It is seen from records that the respondent number 5, that is the headmaster of Bandara Girls ME Madrasa, had submitted an affidavit in the filed an affidavit in the matter, and therein it was contended that the petitioner was appointed on 5/4/2025 as an assistant teacher to teach the subject of social science in the school in question, and that he had joined his services on 7/4/2005. Also, it was further pointed out in the said, it was further highlighted in the said affidavit that the petitioner, the name of the petitioner was captured in the dice code from the year 2009-10 onwards. Also, I've heard the learning counsel for the parties and also perused the materials available on record. While the pleadings as brought on record has from the pleadings as brought on record, and as well as the oral arguments advanced by the parties during the hearing of the present proceedings, it is amply clear that the petitioner was appointed in the school in question on 5/4/2005, and he had joined his services on 7/4/2005. It is further clear that the petitioner was teaching the subject of social studies in the school in question. Also, further, it is not disputed that the respondent number 6 herein had joined the services of the said school on 6/9/2004 and was teaching the subject of Arabic. Full stop. From the communication dated 19/10/2020 as forwarded by the District Elementary Education Officer, Bongaigaon. From the communication dated 19/10/2020 of the District Elementary Education Officer, Bongaigaon, forwarding the service particulars of the serving eligible teachers of the school in question, it is seen that there is another teacher, that is Sri Abdul Batin, who, while functioning as the master of the school, also taught the subject of Assamese and English in the school in question. Also, the provisions of 3:11 of the Act of 2017 being relevant is quoted here in below. 3 Romans 4:11. So, provisions of section 3(1)(11) of the Act of 2017 mandates that in case of a venture upper primary school, there shall be minimum 3 teachers or tutors, and at least one of such teacher shall be posted for the subjects of A, science and mathematics, B, social studies, and C, languages. So the self-distribution and identification of the posts as being are being made with regard to the subject as taught by the teachers whose cases for such provincialization is being considered by the respective, but by the authorities, full stop. In the present case on hand, it is seen that the name of the petitioner as well as the respondent number 6, along with 2 others, were recommended by the jurisdictional district scrutiny committee for provincialization of their services. And the matter was also placed before the state level scrutiny committee. From the affidavit filed by the respondent number 2 hearing, it is revealed that the only reason for not considering the case of the petitioner for such provincialization is that in the recommendations as made by the district scrutiny committee, the jurisdictional district scrutiny committee, the date of appointment of the petitioner, date of joining of the petitioner in his services was reflected as 7/4/2015 in place of 7/4/2007. So, the said issue, as evident from the pleadings brought on record by the parties to the present proceedings, as well as the communications available on record, but wherein the particulars of the serving eligible teachers of the school are reflected, shows that the said conclusion as reached by the respondent number 2 in the matter is perverse. The petitioner had admittedly joined, but the petitioner admittedly was appointed on 5/4/2005 in the school in question, and he had joined his services on 7/4/2005, and there can be no dispute with regard to the said position. So, that being the position, the reason that being the position and the reason as assigned by the respondent number 2 for not considering the case of the petitioner for provincialization of his services after his name was recorded, were recommended by the jurisdictional district scrutiny committee, this court finds that the petitioner was denied a due and fair consideration for having his case considered for provincialization of his services against the post of social science teacher in terms of the provisions of section 3(1) bracketed Roman 11 of the Act of 2017. Also, although the the respondent number 6, although is not at fault for the provincialization as affected in her case, provincialization of her services as affected by the order dated 5/2/2021. However, it is seen that the respondent number 6 could not have been favored with such provincialization of services to the exclusion of the petitioner hearing. This court has come to the said conclusion in as much as the provisions of section 3(1)(11) mandates that only one post of language teachers is required to be so provincialized in a school, along with that of the post of science teacher as well as the post of social studies teacher. It is seen from the report of the district scrutiny committee, the enrollment status of the school prior to the provincialization of the services of the teachers therein did not mandate the creation of did not mandate the sanction of an additional post for the school in question and or for provincializing the headmaster serving in the school as the headmaster of the provincialized school. So in that view of the matter, the provincialization as affected in the case of the respondent number 6 cannot be sustained inasmuch as the same has caused severe prejudice to the rights of service interest of the petitioner hearing. Accordingly, this court interferes with the at this stage, it is to be noted that this court, while issuing notice
26/3/2021.
When is it?
26/3/2021.
This court, while issuing notice in the present proceedings on 26/3/2021, had, considering the prejudice caused to the petition herein, directed that the benefits of provincialization be not given to the respondent number 6 herein until further order. The said interim directions continue to hold the field as on date. Also, in view of the above position and the conclusions reached herein above by this court with regard to the provincialization of the services of the respondent number 6 herein, the provincial, the such provincialization of the services of the respondent number 6 is hereby interfered with, and accordingly the order dated 5/2/2021 passed in this connection by the Director of Elementary Education Assam is set aside. So, having set aside the above by the provincialization of the services of the respondent 6, the Director of Elementary Education Assam is now directed to place the case of the petitioner before the State Level Scrutiny Committee by disclosing the actual and correct date of joining of the petitioner in his services as noticed herein above in this order, and thereafter to have his case considered, scrutinized strictly in accordance with the provisions as existing in the Act of 2017, and thereafter basing on the recommendation as would be made by the State Level Scrutiny Committee to process the matter further for provincialization of the services of the petitioner herein. Also, the said exercise be initiated and concluded within a period of 3 months from the date of receipt of a certified copy, along with the forwarding from the petitioner. Also, the services of the respondent number 6 having been interfered with for the reasons as assigned herein above, will not bar the respondent number 6 to approach the respondent authorities by way of a representation highlighting the stand as taken by the said respondent before this court. Also, the said respondent shall also be permitted to urge any further grounds as may be available to her. Also, in the event of any such application being filed, a representation being filed by the respondent number 6, the respondent authorities, the respondent number 2, before the respondent number 2 will give authorities number, respondent number 2 shall give the same its due consideration strictly in accordance with the provisions of the Act of 2017. However, it is to be noted that the consideration as would be made in the case of the respondent number 6 should not be at the cost of the petitioner, and in the event the petitioner is found to be eligible for being provincialized in his services by the State Level Scrutiny Committee, his such provincialization shall not be stalled on account of the representation now being permitted to be filed by the respondent number 6. With the above observations and directions, the petition stands disposed.
Only one thing, regarding that, rightly or wrongly, he has served.
There is a stay order.
But then
I have permitted you in that case, this case.
No. Then your lordship may, if your lordship,
In the event the petitioner, in the event the petitioner is found to be recommended by the State Level Scrutiny Committee to be provincialized, to be eligible for provincialization of his services, his such provincialization shall be effected from 1/1/2021.
yes. Now, what I'm saying, where your lordship has given me the permission to approach the authority, over there, in my representation, I may have the option of claiming
No.
the.
You will not. because we are permitting him from 1/1/2021.
But that can be, as your lordship has.
That
declared
case
another
was a
case.
different
No,
case.
no, what I'm not saying that. Obviously, from the day he will start working, he will get the salary.
No, he's working still. Only that
No, he's
growth
not
has to
working.
be put over
He's
him.
not
He's
going-
working.
No, he's not going to the school. I am working.
That is something else. Go and file a civil suit for that.
No, but I think your lordship should give some kind of a mercy to a person.
Mr. Abedin is never happy.
No, no,
That's
no.
the issue.
Is there anything to be happy today?
Why? I'm giving you a liberty.
My lord, that liberty is kind of a curtailment. Is not a liberty in exact
See,
sense.
a person has been denied his dues
I understand.
only on the
No, no,
plea.
what I'm
No,
saying-
no. Only on the plea that he is an appointee of 2015. And see the level of consideration, application of mind by these
Well,
authorities.
I'm not against
This is
that.
not called for.
What I'm saying, rightly or wrongly, I have been provincialized, I have worked. The lady is also serving from 2004 before him. Let her go with those much of salary of 10,400 per month. At least for the period working.
My lord, that up to the government, my lord.
You want to give up 10,400 till you join? Want to give up? Tell me. Tell me. I'll allow. But if you don't consent to that, I'll not allow. Mr. Ghosh will not consent.
I think no, he should understand, no, he will consent. Because in other case where I got an order for the provincialization, it was prospective. It was not retrospective with the financial benefit. So that money will anyway go.
No. Here we have said this because his case was rejected
I
on
understand.
a perverse ground.
I understand. I'm not on that. I'm saying, my lord, what is my fault?
I've said you have no fault.
Yeah, but I worked. At least for that labor.
Otherwise also you would be working.
No. Now, possibly no. No, I'll go. That representation will do nothing because they will get, with your lordships commanding mandamus, are they going to play with my appointment any further? No. What I'm saying, I have worked.
Okay,
This-
we'll think about it. Mr. Ghosh, we may think over it. Kuntu,
Peaceful farewell, my lord.
22. Hey, that VRS matter.
That we have given.
We have passed the order. We have asked on the strength of that only. From 23, you have been asked to go. We have said you are now that they have accepted that. We are not going to examine any of the issues. However, within a period of 3 months, your pension and pensionary benefits should be clear. That much only. They have already did it.
Deeply obliged.
Yes.
That one.
She has any matter.
Secondly.
Obliged.
Deeply obliged.